We're not expecting anyone.
Okay, Lasha, ready?
Yes, sir.
3, 2, 1. We are live.
Very warm welcome to the esteemed dignitaries from academia, law enforcement agencies, law officers, faculty, students, and other stakeholders who are joining us online as well as physically at the conference hall. Symbiosis Law School, Pune, a constituent of Symbiosis International Deemed University, is honored to host the roundtable on police, security, rule of law, and human rights. Crime is an inevitable phenomena of every society, and when it comes to the largest democracy in the world, with rule of law at the foundation, law is a vital instrument of establishing peace, security, and ensuring the rights of the people in India. Each law enforcement institution, including the police, defense services, and courts, are shouldered with the enormous responsibility to uphold the rule of law and maintain order in society. This roundtable is organized with the view to deliberate on the changing facets of law and enforcement agencies and the issues and the challenges that they are faced with, as well as to chart a future course for enforcement, investigations, and justice delivery systems through law reform. We are honored to have the esteemed representation of the roundtable today from members of academia, both national as well as international, professionals, law enforcement agencies, including police, defense services, and other relevant stakeholders to put forth their views on the topic. We will now commence the program with the lighting of the lamp, as is our custom. I request all the dignitaries to proceed to the lighting of the lamp. I request Professor Dr. Shashikala Gurpur ma'am to lead the way. Dr. Mohanty. Thank you very much. Now, to deliver the welcome address and the overview of the theme, police, security, rule of law, and human rights, it is my privilege to introduce to the August Forum, Professor Dr. Shashikala Gurpur, full rights scholar, Director, Symbiosis Law School, Pune, and Dean Faculty of Law, Symbiosis International Deemed University, and Jean Monnet Chair Professor of EUC LAMP, co-funded by the European Union. Professor Dr. Gurpur is an accomplished academician, a passionate researcher, a Toastmaster, and a Fulbright scholar. She holds a PhD in international law. She's a PG topper with 3 gold medals and was the AHRB visiting fellow to the Edinburgh Law School, UK in 2004. She was selected for the Fulbright Nehru Administrators Seminar in 2011, and she's the recipient of the annual Kittur Rani Chennamma Award in 2018. She was a member of the Law Commission of India from 2010 to 12 and has annual membership of the Asian Law Institute Singapore, of the IALS, ASLI, IUCN, etc., to name a few. Dr. Gurpur has over 80 research papers, 2 co-authored books, 15 book chapters, and 4 magazine articles. She's also a listed poet and an author in Kannada with more than 8 publications. She has presented more than 340 invited lectures, workshops, and seminars, guided more than hundreds of master's students and 12 PhD awarded students, and is currently guiding 8 doctoral research students. As the Dean of Symbiosis International Deemed University and Director of Symbiosis Law School, Pune, since 2007, Dr. Gurpur has relentlessly spearheaded the internationalization of legal education at a global level. She is currently monitoring research between Indian and international universities across Thailand, US, UK, Ireland, Germany, Australia, Canada, and the UAE in academic and research outreach programs. International research projects like Eurasia 21st State Skills Project, CCP Law, ILFM, DAD, and Erasmus grants, in addition to holding the prestigious Jean Monnet Chair in EUC LAM. Dr. Gurpur has received many awards and recognitions for her contribution across all domains of law. She is among the top 100 legal luminaries of India. I invite you now, ma'am, to deliver the welcome address and give the overview of the theme of today's roundtable.
In sharing to this. Respected Lieutenant General Rajendra Nimborkar, sir, a good friend also, and esteemed Mr. Arvind Patil, Madam Varthak, most of all my esteemed colleague who is on a visit now, Professor Eckhard Strauss from Berlin School of Economics and Law, esteemed colleagues on and off the dais, especially joining us virtually, the Dean of Tata Institute of Social Sciences Law Faculty, Dr. Arvind Tiwari, from the Raksha Shakti Police University, Dr. Akshat Mehta, and many other colleagues and friends, students, scholars, and international scholars who have joined from across the world and across India. A very, very warm welcome on behalf of Symbiosis Law School, on behalf of Symbiosis International University. As the Dean of Faculty of Law, I also have the privilege of introducing to you our sister law schools, which are in Nagpur, Noida, and Hyderabad, from where the representatives have been attending this event. This event was planned like how we have flash floods in Pune or lightning and thunderstorms, with the visit of Dr. Strauss, who we discovered has a very rich experience in United Nations enforcement action, especially it's not enforcement of the force, but it is enforcement of the moral force, the humanitarian force. So his various roles and the rich experience, we thought we will bring it to scholars in India. We'll have a very healthy debate among the stakeholders of state security and human rights vanguardship, and also among scholars to raise certain fundamental questions about our approaches and to discover answers in this roundtable discussion. I must tell you that India is a country, Professor Strauss, which has been recognized even in its colonial period for its excellence in intellect through Tagore's Gitanjali, which won the Nobel Prize for Literature. It was late Mr. Tagore who said that restraint, beauty is in restraint. So ours is a culture which is more of restraint than licentiousness. But when it came to human rights, we have been accused from across the world of being in that kind of licentious or excessiveness, which goes a little bit against the tenet of what we believe as an evolved civilization. So I was wondering, on the one side, when we have restraint as the utmost value, on the other side, we have had, the whole idea of learning this police state culture from colonialism and then retaining it in the post-colonial state building process, because we had to unify India against so many challenges. Over the years, we evolved as a democracy. We have still stood as one of the greatest experiments of democracy in the world, especially maintaining differences and managing differences and diversity through the preamble and the philosophy and the living nature of the Constitution. We have, from our colonial legacy, one principle we have inherited, one philosophy: let the 1,000 guilty escape, but not one innocent be punished. So this restraint is there in our criminal law jurisprudence in the way we have organized the criminal justice system. But all students of comparative law would agree that as the colonialism spread from the heart of Europe or other parts of Europe as it then was, it also spread the inheritance of the criminal justice system with the kind of adversarial system as the predominant nature of common law system. Now, with a strong state, as it was to be envisaged in the post-colonial discovery of democracy and experience, and at the same time maintaining security against internal and external challenges, the Constitution balanced this in terms of restrictions, and again, restrictions being restricted by reasonableness. So it was a kind of freedoms on the one hand to citizens, on the other hand, state as the institute having the duty to protect that freedom. But then while protecting the duty, state's powers had to be strengthened by means of giving it the power to restrain this freedom. But then state had to be kept under check by invoking the principle of reasonableness. So every instance of state's power has been tested through various case laws, and the judiciary has brought back this balance between citizens' rights and the state's powers, duties of the state. So it's a Hoffieldian scheme in a permanent state of dynamism that you see in Indian Constitution's work. And criminal justice system, despite its strong trapping in the colonial tradition that we inherited for only 200 years. And prior to that also we existed as a civilization and society where the concept of prison or concept of incrimination was in a different way. It was more of a reform and contained within the community kind of approach. So as the modern theories evolved with postmodernism and others in terms of debating this power, for me, as I look at this discussion today, the whole idea of rule of law vis-a-vis rule of men, discretion vis-a-vis exceptional use of power is something that begs discussion. So where is this what we call in our Indian culture, Lakshman Rekha, or the boundary of the power and the reminiscence or reminders of the duty, and then the protection of rights. So it's here that we have a number of studies. Our own law school has undertaken through its students' master's thesis of how Armed Forces Special Powers Act and post that act when the Northeast was coming under the withdrawal of that legislation, the whole process of rehabilitation, which you would have done in United Nations assignments in terms of reconstruction of the law and order situation in post-war or war-torn or violence-torn, conflict-torn situations. So this kind of observation was done by one of our students by doing 300 case studies on the field in Northeast. We have had a lot of questions being asked about the judicial nuances made when the police power was being restricted. For example, we had a very historical case which came in mid-90s, Nilabati Behra case from Orissa, where the mother of a young man lost her son because of the excess committed by the police, which was projected as suicide because he was caught in a small theft case. And it was in that case that for the first time, Supreme Court made an independent police officer to investigate on the whole issue by a committee which was headed by a judge. And it revealed that it was not that he committed suicide, but his death was by torture by the police to evince some kind of truth. And then he escaped. The police version was that he escaped and committed suicide on the railway track, and he was killed by running over of the train. But the later forensics revealed that his death had happened by breakage of a neck bone, which must have occurred during the process of tying him to a chair because there was no proper lockup available to the police in the police outpost in that area. So Nilabati Behra case for the first time revealed how, along with the concept of punishment, there had to be an approach to compensation. There had to be an approach to make the state liable. It was not the first time. There were blinding cases in the prison. There were other cases whereby excesses in order to prevent the crime or investigate the crime would have resulted in some extreme outcome of death or torture or injury. Now, powers of security forces, because security is one of the reasonable restrictions under the Constitution, which is again qualified as law and order in the police sense. So state security, public security, which is a precondition for exercising human rights. And in the excess of the power of protecting this security, when the human rights are violated, this is the dilemma that a student of justice or law faces, or a scholar faces. And this must be the kind of research that you would like to bring to the table from the transnational experience of your earlier assignments and from the focus of your school, Berlin School of Economics and Law. So what is the kind of necessity of approach to restricting or reasonably exercising this power? How do we put it on the basis of legality? How do we put it on the basis of necessity? Because they say necessity knows no law. We have that principle as well. How do we bring the proportionality standard in terms of use of force by the authorities? Are third degree methods necessary when the civilization has reached the height of technological evolution, whereby technology, it's possible if someone was present or not in that situation to detect? So where do we place this? So this is a refined mind lab, this roundtable discussion. And we have many refined mind labs in the think tanks, in the research groups in the West as well as in India. Policy decisions and policy researchers, all of them are looking at this. Police themselves have, or armed forces themselves have individuals who think from the point of view of human rights. So there is curriculum introduced to the training. There is a law faculty who is absorbed into the Defense Training Institute that I'm aware of. So with all this, how do we look at these mutually contradictory, competing, debatable issues is the crux of today's roundtable discussion. I'm sure scholars across the country and the world and who are present in this roundtable and the experienced officials who are here, who themselves would have handled such situation, would enrich this discussion for our students and scholars and for our guest scholar from Berlin School of Economics and Law. I'm very happy to welcome each and every one of you with this prelude to the discussion. As I also tell you that this event assumes importance for Symbiosis International University and for the Faculty of Law for three reasons. One is our university, as the word international stands, we have that in our DNA to look at whole world as one family, Vasudhaiva Kutumbakam. In furtherance of that, the very birth of Symbiosis was to support our international students in Pune who were from African and other underprivileged backgrounds. Dr. Muzumdar's whole mission was to integrate them and assimilate them into equitable foothold in learning and evolving way back in 1970s. So today, internationalization in the higher education assumes different shades and meanings. With the enrichment of a collaboration with the European universities and European Commission's grants, etc., we have looked at 9-point internationalization. So this knowledge exchange and new knowledge creation, resulting in publications probably, or some kind of media mediated awareness, is definitely going to impact the discourses on the balance between people's human rights and constitutional framework in the life of this country. Now, second reason why this assumes importance is we believe in learning from visiting scholars and learning from other legal systems so that we exchange best practices. We learn their best practices, especially with the people like Professor Strauss, who have been in the mission of United Nations in re-establishing democracy, rule of law, and human rights in the war-torn, conflict-ridden, liberated landscapes across the globe. So that is something like a first-hand authentic narrative. You know, they say that the best leadership is authentic leadership. So if you're looking at thought leadership, the authenticity comes from that experience, which is very rare for our students to get. So that's the second reason why today's event is important. The third reason is within fall of a hat, our whole faculty came together. They pressed their public relations and network into service from across India and in Pune. And we have eminent people like Mrs. Varthak or Mr. Patil or Lieutenant General Rajendra Sir, or now high-level police officer Ms. Purnima, who is going to join us, among others. So this wouldn't have been possible but for the teamwork and the core commitment of our team to the values of internationalization and human rights. So I also, as I welcome, I also place this note of appreciation and gratitude to each and every one of you for trusting us for joining us and for contributing to this mission. Welcome, Ananda.
Ma'am, for that warm welcome and the insights and highlighting the critical questions that we are going to be discussing today. You laid the foundation and set the stage for a robust discussion that will surely ensue. Now, I would like to invite Professor Dr. Shashikala Korkor ma'am once again for the felicitation of the dignitaries. So we firstly have Dr. Eckhard Strauss, Professor of Public Law, Berlin School of Economics and Law, Germany. I'd request you to felicitate, ma'am. We also have Lieutenant General Rajendra Nimborkar, PBSM, UYSM, AVSM, former officer of the Indian Army, Master General of Police. We also have Mr. Arvind Patil, ACP, retired ACP. A very warm welcome to you, sir. Change. We also have Advocate Neelima Vartak, former government leader. A very warm welcome to you, ma'am. Also joined online by Dr. Akshat Mehta, University Dean and Associate Professor, Raksha University. So a very warm welcome to you, sir. We will now begin with the roundtable deliberations. Just to ensure that the participants are aware, the participants' questions will be taken towards the end after all the dignitaries have delivered their addresses. The chat will then be enabled at 1 p.m. for the same. We request that all the participants post your questions in the chat once the chat is opened. Now, to begin with, I would like to, it is my honor to introduce Dr. Eckhard Strauss, Professor of Public Law, Berlin School of Economics and Law. Dr. Eckhard Strauss has been appointed to a professorship for public law, in particular, fundamental and human rights, and police law at the Berlin School of Economics and Law since October 2020. Dr. Strauss was a senior human rights officer to the UN, was the resident and humanitarian coordinator. His doctoral thesis concerned with the prevention of human rights violations by international organizations. He was the special advisor to the UN Secretary General on the prevention of genocide, the UN Department of Political and Peacebuilding Affairs, and the OHCHR. This covered the Eastern and Central Europe, North and West Africa, Southeast Asia, and the Middle East. He was also a research fellow for the Asia Pacific Center for the Responsibility to Protect and a representative of the head of office of the OHCHR. We are very honored to have you here, sir, and to deliberate on the topic experience on best practices on police and human rights. We would kindly welcome you to deliver your address now.
Thank you very much.
Anyone here?
Thank you. Thank you very much. Professor Gorpur, honorable guests online and here in the room, thank you very much for inviting me to this roundtable. I must say I'm deeply impressed by the fact how the discussion we had on Monday with Professor Gorpur actually is turning into a roundtable like this only 4 days later. And I think it speaks, as you said, to, of course, the ability and dedication of everyone who is working here. But I think the number and expertise of participants also speaks to the standing of Symbiosis Law School in teaching and research. Opportunity to also thank you for this very interesting visit I'm having during this week. Given the expertise and experience around this table and online, I'm reluctant to present my own as anything more than a personal account. I would ask you to please take it as such, and I hope that this personal account will trigger some thought and discussion as far as it originates from outside India. I'm not an expert on India. In preparation for this roundtable, I looked in a cursory manner at the institutional structure involved in issues related to the police and human rights in India, some of the civil society analysis during the past years, and decisions by the Supreme Court and the National Human Rights Commission. I looked at the training material and the publications by the police itself. Reading this material, it is striking yet again how much the analysis, the identification of causes, the underlying problems, and the response strategies resemble those of the diverse countries I worked in. I have worked in countries ranging from monarchies like Morocco or Jordan to an Islamic republic like Mauritania, or post-war democracies in former Yugoslavia. Looking at the security challenges identified by all of these different countries, we also find an almost identical list. Terrorism, organized crime, gender-based violence, drug-related crime. It is not a surprise that the response looks very similar as well. We see in this, I think, the shift from identifiable threats we had in the past to the more opaque, high-risk, low-probability scenarios globally that we are all facing. While the general shift in security management has been analyzed, also in academia in this regard, I have the impression that the particular role of the police does not seem to have given the same attention everywhere, apart from increasing their powers further into the preventative area. Looking at the corresponding uniformity of responses to the human rights challenges involved in these response strategies to the present security challenges and their impact, something does not seem to work. Human rights violations continue, notwithstanding training, monitoring, and accountability mechanisms. These are not working perfectly everywhere, but they cannot be the only response either, looking at the situation where they almost do work. In my eyes, legal research could contribute to reframe some of the issues and open new perspectives. And I would like to share a few thoughts in this regard. The reason for human rights is human dignity, which can be justified based on different religions, cultures, traditions, and so on. This is the result of different human rights developments at the national level. The reason why human rights are an international concern is the shared historic lesson from the 1920s and 1930s, in particular in Germany, that the repression within a country leads to aggressive action to the outside world. I think in discussing human rights and assisting each other.
Sorry to interrupt. There's a little bit of problem of volume. So could we request you to go there and use that mic because it's a little more voluminous. It's the problem with the technical side.
Amit is saying sound is perfect.
Just
But Amit is saying from there.
it is not audible. So what is perfect? Can you adjust that?
The first thought I was referring to was that the reason why human rights exist is human dignity. This can be justified based on different religions, cultures, and traditions. It's open to different cultures. This is the result of different human rights developments at the national level. The reason why human rights are an international concern is this shared historic lesson from the 1920s and 1930s in particular in Germany, that repression within a country leads to aggressive action to the outside over time. I think it's an historic lesson that we still make until today. Just look at the situation of the world. In discussing human rights between us and assisting each other, we should clarify the distinction of these two reasons. Looking at the preamble of the Universal Declaration of Human Rights, the violation of human rights is one of its underlying assumptions. Human rights will be violated because people are psychologically evil. This is not a failure of human rights, it's part of it, it's part of the system. Since we need the physical protection of the police to realize human rights, this cannot be constructed as a pacifistic vision. Therefore, we should look at the normative level on which human rights violations actually occur in a particular country. Does state action infringe on the scope of protection of an absolute right, like the prohibition of torture? Or does the action or omission is based on a legal authorization and violates the principle of proportionality? These violations have a different quality with regard to the question of their prevention. The former needs clear accountability, the latter analysis and experience over time of the officers concerned. While there is a polarized discussion about human rights as a Western concept, in fact, in response to terrorism, government measures were quite unified. Limitations to human rights. The analysis of these government measures is ongoing and there are a number of important findings, but in essence, this response seems to show, at least to me, that governments and their populations do not believe in the positive benefit of human rights for the context of security. Unless we are able as human rights lawyers and advocates to show this benefit, the discussion will remain emotional as we question each other's respect for human dignity. The dialogue between security forces and the population should start from the truth that whoever realizes his or her rights, e.g. the right to assembly, infringes automatically on the right of others. Those, for instance, who would like to go shopping at the same place. Our training, which actually should start earlier than in police, we should start in primary school, needs to promote conflict as the desirable state of human rights. This is what human rights is about. It's in the realization, but to clearly define its limitations. And this should be the limit of violence. This will and may make people, including politicians, more confident and feel more secure in an atmosphere where you need to find a kind of balance between different realizations of rights. The reason for the distrust in human rights in a particular security situation vary from society to society and within it. We need to look at human rights holistically, so make an analysis what the status of human rights in a particular country is, and then set priorities, which rights to address at a certain time and a certain place. This is not a violation of the principle of indivisibility of human rights, but a consequence of their quality as legal norms at the same level. So for our discussion today, I hope, and I was looking forward to learning more from you, how you are looking at this situation of tension between rights, the demands of security, but also how a society looks at it in a very diverse manner. I think there are a lot of opportunities for, in particular, legal research on this issue. I would be interested in those who worked on this in practice. What are your needs? What are your interests in research? What are you missing to actually have a practical response to how to improve human rights protection in responding to those security challenges. Thank you very much.
Thank you, Sarah, for bringing your valuable international experience, which is extremely relevant in the context of issues faced by Indian law enforcement agencies as well. Thank you very much. I would like to inform the House that we also have online Dr. Arvind Tiwari, Professor and Dean, School of Law, Rights and Constitutional Governance, Tata Institute of Social Sciences, here with us. We warmly welcome you, sir, to this roundtable. Dr. Tiwari is the Dean of School of Law, Rights and Constitutional Governance, Chairperson of the Center for Police Studies and Public Security, School of Law, Rights of Constitutional Governance. He's a professor in the Mumbai campus of the Tata Institute of Social Sciences. He previously worked in the Nodal Center of Excellence for Human Rights Education at TISS. As a reader or associate professor in the Department of Criminology and Correctional Administration, president of the Indian Society of Criminology and the vice president of the Indian Society of Victimology. I invite you now, sir, to deliberate on the topic of police accountability in India. A very warm welcome to you again.
Hello,
Yes,
am I audible?
Yes.
Yeah. Very good morning to all of you. And I'm thankful to Symbiosis Law School and International University for inviting me for a brief interaction. Sorry, I could not join physically because I was busy with some kind of other commitments. So, Professor Sasikala Gurpur, faculty colleagues from the Symbiosis International University and Law School, Professor Strauss, Dr. Akshat Mehta, other resource persons, offline, online, and esteemed participants. I would like to briefly raise the issues and some kind of ideas, because this is a very good opportunity for all of us to have Professor Strauss in Pune. And this discussion, I would like to just raise issues pertaining to the police accountability in India, and how we can see that police is accountable to the people, but at the same time, before I'll take through accountability mechanism, I would like to say that in India we have two kinds of police system. One, the central police organization, CAPF, which we say, BSF, CRPF, and various kind of central police organizations, which are helping the civil police as and when they are required. And another is the civil police, which is the jurisdiction of the state governments. Now, you know, with the proliferation of the, science and technology, a population increase, complexity of crime, and the kind of crime which are being increased. So, looking into this, the police has very Herculean task. So we cannot imagine a civilized society without the police. So the contribution of the police, we have to salute to the police officials, because they are working day and night. And even during the COVID time, we have also seen that how our police officials, they have done a wonderful job. Although there were some aberrations which would have been avoided. Otherwise, in general, the contribution of the police was immensely significant and important for all of us. And second thing, after independence, around 35,000 police officials, they have sacrificed their life while on duty, while discharging their responsibilities on duty. So we have to understand their contribution. If just for the participants' purpose, I would like to bring to their notice that around 80 to 85% of our total police force consists of constables, and later on the sub-inspectors and inspector and at the hierarchy up to the IPS officers. So bulk of the police force is of constable. They have also different kind of problems. So I'm not going to that. I'm just trying to bring the overarching perspective of the police, that the police in the post-colonial countries, India, we have inherited the system from the Britishers. And even after 75 years of independence, Police Act of 1860
Some interruption.
was imposed emergency in 1975, so which is called the Dhanvira Commission, and then several committees and commissions were constituted by the central and state government, and which have given wonderful recommendations for the police reforms and police accountability. One important judgment which was delivered by the Honorable Supreme Court in 1996 was Prakash Singh, 2006. The petition was filed in 1996. Prakash Singh and others versus Union of India. This judgment is the path-breaking kind of judgment which has given the accountability framework also of the police. Now, what is the meaning of the accountability? In a simple manner, accountability defines as a system of internal and external checks and balances aimed at ensuring that police carry out their duties properly and are held responsible if they fail to do so. Such a system is meant to uphold police integrity and deter misconduct, or to restore or enhance public confidence in policing. So that means the police in any democratic country should be accountable ultimately to the people. Now, we have the accountability mechanism in our country. We have the internal accountability mechanism where the entire hierarchy is there, the police hierarchy, starting from the police station up to the DGP. And we also have the external mechanisms such as judicial, like the Supreme Court, High Court, and the other courts, as well as also quasi-judicial bodies like the National Human Rights Commission, State Human Rights Commission, and other human rights institutions. So it is not that we do not have accountability mechanism, and a lot of case law is there. If we will see emanating from the judgments, as well as the NHRC and SHRC orders which have been delivered to them by these, which I have given a lot of framework to that. Briefly, I will, because this students and teachers are also there, I would like to highlight few issues which could be taken up for the study or for the further intervention. Like the Prakash Singh judgment has given 6 major directions. That first is that each state government must constitute a state security commission to ensure that police are protected from illegitimate political interference. One of the major concerns, David Bailey, also Professor Bailey, 50 years back has said the same thing, that there is a lot of political interference, which is also, situation is not much changed, rather it is worse. So we have to be that how this state security commission is functioning. We have to do the studies. We have to find out who are the members, what are their mandate. Second, fixing of the selection and minimum tenure of police chief, DGP. So because you know that once the government is changing, the DGP is changing. So we have to see that how fixing of tenure can be done. Number 3, minimum tenure of other police officers, including Inspector General, IGP to down, up to the station house officers. Next was very, very important direction, separation of investigation from law and order. Because the crime investigation is a very, very intelligent kind of work. But police being busy in a lot of maintenance, VIP duties, and many other kind of unforeseen eventualities in the society, police are supposed to be there as the first responder. So how this separation in some states this is done for namesake, but broadly this is not happening. Next was the setting up of the police complaint authority. Like in Maharashtra, we have the state police complaint authority and the regional police complaint authority at the commissionerate level. I call upon the researchers and students to do the auditing of these. Who are, what is the composition of these committees? What kind of mandate they are having? whether people are aware, those who are victims of police atrocities, that there is the police complaint authority, and how to take up their complaints. What is the procedure for that? This is the you see, need of the hour from the societal point of view, from the academic institution point of view. And another was setting up of a National Security Commission and the Police Establishment Board. So this, although many states, around 17 states, either they have amended their law, Police Act, or they have enacted a new law. However, the major thrust of the police accountability towards people is not there. So how we can see, there are some experiments on like the community policing and other kind of you see processes with the police, several police departments across the country. They have initiated and they have done a wonderful job. But whether all these initiatives which are towards people-centric are being taken care of in their performance appraisal. So what is the performance appraisal of the officials when their performance is being assessed, whether these factors are being counted or given any kind of preference or any kind of weightage? That is another area to research on. Then how many civil society organizations, they also publish report and also find out the case studies where the violation has happened, or like say the suspension. If any incident is happening in the police and the police people are found prima facie responsible, they are being suspended. But if somebody will do the study that up to what extent these suspended people, if they are found guilty, are being terminated from the job, perhaps the percentage would be very, very less. I'm not saying all should be terminated, but at least this should be studied, that against whom the serious violations are proved through the inquiry, thorough inquiry. What is the status of that? Perhaps this is also another area to work. Then media interaction, and media now, social media and electronic media, and many these stories are being flashed by these media. We have to see that auditing of these kind of issues which are being raised by the media relating to the violation of human rights, and what is happening when the violation of human rights is happening of the people, like custodial violence, custodial torture, and the after 1970s, friends, we know that the new phenomena in criminology and the criminal justice is emerged, that the state crime. So how we can also do the studies, the evidence-based studies, empirical database studies, that the state crime phenomena, custodial violence, custodial death, illegal arrest, non-registration of crime, fair investigation of crime. We have to see the police corruption and accountability, political interference versus interface. Interface of the political leaders would definitely have with the police, but that should not be converted into interference. So perhaps we have to see this. We have to see the police subculture, like training. What kind of training is being imparted? Whether the training, because we need a lot of, one police officer did PhD under me, IPS. And we have, he has brought out several issues pertaining to the training. Training is one of the areas which is also neglected from the researcher side. And we are just thinking that if there is some law, there is some judgment, that judgment's implementation would be done on the ground. Friends, no. Because if the training, if the work culture, if the subculture, if the working environment at the police station level, the gender mainstreaming of like the women police officials, those who are there, that is also required to be looked into through empirical studies. And also public satisfaction on the police services. How people are satisfied. Are they satisfied? If not, on what issues they are not satisfied? And from the police side also, we have to also do the study from both sides, from the police official side as well as from the public side. What are the public expectations from the police, and what are the expectations of the police from public? And some annual kind of report should be, if that is being developed by the district police or the police station in consultation with people, I think public satisfaction can increase. So we have to see this aspect also through our studies. The challenges which I feel are like political economy of crime registration. This is one of the area, and several judgments are there. Lalita Kumari and several judgments where we all know that the crime working or the huge problem across the world, not only in India, all countries developing. So how to minimize that? Second thing is the police reform, as recommended by various committees, commission, and the higher judiciary in several judgments. Why this is not happening? Only is it the lack of political will or bureaucratic will, or also we do need several kind of internal transformation within the police department. What are those? Because if we'll see the normative structure, there's no dearth of normative structure relating to police reform. Despite that, the adequate reform are not visible at the ground. What are the impediments for that? This is the area for research to the universities. Then politicization of police force. How the politicization of police force can be minimized, and what kind of accountability mechanism should be put. Although we all know that the crime investigation, the police is free. Even the contemporary present law also says that. However, there are several incidences which are reported. I think we have to look into this perspective. David Bailey, as I said you earlier, has done wonderful studies 50 years back. We have to revalidate and see what are the current scenarios. Now, weak accountability mechanism. So, a weak accountability mechanism also, like, because of that, some police officers, those who are violating the law, perhaps they feel they are above the law. Not all. Many of them are doing wonderful job, and we have to appreciate, as I said in the beginning, but some of them still violate. Section 197 of the CRP, which makes provision for a prior sanction by the government for prosecution. I think this also need to be revisited, and we can see that how we can make the police officials accountable. Now, the way forward, which I would like to just highlight, that the who will, and these are questions, I mean, for further debate, like who will police the police? This is the first question. So, of course, the police department within the hierarchy, and also external mechanisms, the media, and how the public education, because we all know, friends, the public education and advocacy about rule of law in criminal justice system is very, very weak in our country, in India. Although like Rajshahi Raksha University and some of the university departments of criminology, law, they are working, but still public education is very limited to the selected people, selected kind of students. Next is the reform in the Police Act, regulations and rules, etc. We need to also bring the transformation in those. Separation of crime investigation and law and order. We have to do the thorough advocacy on this and the research studies that in some state this is done, but up to what extent, what kind of manpower we need, what kind of other infrastructure is required so that the crime investigation, because the acquittal rate in very serious crime is very high in our country. There may be several factors for that, but the crime investigation, quality crime investigation is also one of the issues, how that can be done, because that is also one of the accountability framework where the police is accountable for their job. Similarly, strengthening human rights institutions, human rights commissions, human rights institutions, also they should be strengthened, and they should, because they are carrying out this kind of auditing of the police accountability, that should also be done. Reform in the criminal law and criminal justice system. We all know that a committee has been set up by the Government of India, Ministry of Home Affairs, which has submitted the report. So now reforms are required. This committee, we understand that has suggested several radical reforms in the criminal law and criminal justice system, and the legal framework for police accountability is also necessary. So I would like to summarize, because I have been given 15 minutes time, and I think I have completed that time. So I would like to say and conclude my address that police in our country or anywhere else, police is a very, very important institution for the public security. And police is also under several kind of pressure. And we have to look into the police and the criminal justice system in such a, like what percentage of GDP is being allocated to these sectors. We have to do the analytical study, this budgetary allocation. So there are several areas which we have to look into, but I would like to conclude that the police in India, if we will say, that is doing commendable job, although there are some incidences which are untoward, and the accountability of the mechanism should be strengthened, and the internal accountability mechanism and external accountability mechanism should be empirically undertaken by the universities, so that, because there is a concept in the criminology, that the translational criminology, that the justice functionaries and the academician should work together, and they should come together and see that how they can bring the better law and order, better public security, and rule of law. Very recently, NEP 2020 in India has introduced the concept of the professor of practice, which is a very good idea. Perhaps I think this we have to see in future that how this concept is working, and perhaps the association between the criminal justice functionaries and the academia will take up these challenging issues, and we will move forward in protection of the people and protection of the society. So thank you very much to all of you for patience. Thanks.
Thank you very much for your keen insights on internal as well as external mechanisms for accountability in India. You also discussed points where you can attract responses and research in policy reform and affirmative action. So thank you very much, sir. It is now my privilege to introduce the next speaker, Lieutenant General Rajendra Ramrao Nimborkar, who is a former officer of the Indian Army who served as the Master General Ordnance. During his career, he has been awarded several commendations. He has been awarded the Sena Medals for Gallantry and Distinguished Service, Vishisht Seva Medal in Akhnur sector. He received the Uttam Yudh Seva Medal in Nagrota. He received the Ati Vishisht Seva Medal in South Kashmir and the Param Vishisht Seva Medal as the Master General of the Ordnance. Lieutenant General R.R. Nimborkar currently serves on the board of advisory of Urchalo, a firm whose CEO is incidentally the student of Symbiosis Law School, Pune, and which works with the defense personnel along with Mr. Ligidil Singh Yadav and Dr. Shashikala Burburhan. It is an honor to have you grace this occasion, sir. So to deliver the address on Armed Forces Special Powers Act and its analysis in the perspective of Jammu and Kashmir, I would like to invite you to make your deliberations.
Dr. Eckhart Strauss, Dr. Shashikala, other dignitaries and participants. It's a unique honor and proud privilege for me to be interacting with you for today's roundtable conference on various topics connected with the law. And yours is a very eminent institution in the country, imparting education in the field of law. And whenever I interact with the youngsters, I always feel that my country is in the safe hands. As I always say, we have already done our batting, the inning is yours. You have to take it forward. So before going forward, I'll just take 1 minute and tell you about Pune. You've all seen how Pune is, and I'll try and tell it in my native language, because if you translate it, the color of that is gone. So I had retired from the army in 2018, and I had that same kind of a aura of armed forces. And when you retire as a lieutenant general, you feel that whatever you say, it should be done. And then it happens. So I was going for some of the lectures like this in Deccan, and on the crossing, I saw one young lady on a scooter taking off and breaking the signal, across the rest. And I was very furious as to how can somebody do like this. So fortunately or unfortunately, my vehicle stopped also on the next signal and the girl was there. So I told her, "अगं मुली तू थांबली का नाही सिग्नलवर?" तर ती माझ्याकडे बघते आणि म्हणते, "म्हाताऱ्या, तुला माहित आहे का मी कुठे चालले? तुमच्यासारखे ड्रायव्हर वगैरे नाही माझ्याकडे. मी हिंजवडीला जाते इथून." मी चुपचाप बसलो. पण त्या दिवशी दोन गोष्टी मला समजल्या. सगळ्यात पहिले, तुम्ही आता आर्मीमध्ये नाही आणि तुमचं कोणी ऐकणार नाही. आणि दुसरी सगळ्यात मोठी गोष्ट म्हणजे पुण्याच्या तरुण मुलींच्या नादाला लागायचं नाही. So having said that, let me just go on to the topic per se. I'm here to tell you about the Special Powers Act, which is being said that is very draconian and very mostly the negative things. One of the votaries of reviewing this law is Mr. Chidambaram, who himself was a home minister and said that it should go, or Saifuddin Soz. And one who was pro is Mr. Amrinder Singh, ex-chief minister of Punjab. And there are so many other people. See, ARM is a Special Power Act, and I am talking from the perspective of the armed forces. As to what the man on the ground does, I have spent 17 years in fighting insurgency in Jammu and Kashmir, wounded thrice. Also operated insurgency in Punjab, in Assam, in Nagaland. So I feel for the armed forces. Now let's go into the background. Why Armed Forces Special Power Act? It's actually started in 1942 when the Britishers used the army, and it was a different shape. And when we got independence at that time in 1950, we started the Armed Forces Special Power Act in Nagaland, and then most of the northeast, it was covered by the insurgencies. And therefore, to counter it, the police could not. And therefore, the army had to be called in. And when the army had to be called in, then you need some protection for the armed forces. If the police operates, he is covered under various laws. But the army operates, he doesn't have this law. You are not supposed to do the policing job. And therefore, the Armed Forces Special Power Act is in vogue. Now, why do we want Armed Forces Special Power Act? Like if you are doing all good things, then why do you want some protection? I said, when you go out in the rain, you know that even if it doesn't rain, you still carry umbrella. No, so you have to have some protection. If something happens, then what? This special, most of the things in the north is now, so many districts, out of 42 districts, this Armed Forces Special Power Act has been removed. And rightly so. When there is no requirement, it should be removed, the army is removed. But when we say, when you want the army, then you should have Armed Forces Special Power Act. In 1989, 1983, the Special Power Act was in Punjab, and then it was removed in 1997, because there is no need for it. The Special Power Act came into being in Jammu and Kashmir, and that is the focus in 1990, and still in vogue. But if you are saying that, if you want to remove the Special Power Act, the Special Power Act can only be invoked when the area is declared as disturbed. So if you want to take it away, remove that disturbed area, say that this area is no more disturbed, and there will be no special power, there will be no army. Now, why it is disturbed is when the police, local police cannot take cannot implement law and order, or there is no justice system, or removal of central forces creates adverse impact on the situation. And when these three conditions are met, then area is disturbed. And when the area is disturbed, then you have a Special Power Act. Now, why it was there in Jammu and Kashmir? I will not go in the history of Jammu and Kashmir. Suffice to say, it's an integral part of India. As per the partition, it was attached to us, or it became an integral part of us. by the instrument of accession, a legal document signed by all 525 municipalities, including Kashmir. So it's an integral part of India, so there is no dispute about it. Now, having said that, there are various problems which came into being. We'll go to 1990 or 89 when the problem started. How did it start? That time, if you take back your mind, the young ladies and gentlemen here, so at that time, the situation was such, there's a problem in Punjab, Nepal was against us, Bangladesh was absolutely a kind of adversary, unknown adversary. There was a problem in Sri Lanka and a problem in Jammu and Kashmir has started rising. So therefore, if the enemy doesn't take advantage of this, he is no enemy. And therefore, Pakistan took advantage of this and Ziaul Haq launched the Operation Tobag. And I will not go into the details, you can read about this. And suffice to say, there are certain parameters of this operation, how it is achieved. And the parameters, firstly, take the control of radios, take the control of press, take the control of the population, and exactly did this. And in 1990, there came a day when about 2.5 lakh and little more of the Kashmiri Pandits were made to leave the valley. It's an exodus. Can call it a genocide because about 237 boys, girls, and ladies and men lost their lives. And I was a witness to it from the other side as to what all has happened. It is truly, non-believable. I can only say and say with conviction and truth can hear from the horse's mouth that locals who were the non-Hindus there told the Pandits that अगर अपनी जान बचाना चाहते हो तो यहाँ से चले जाओ और जाते जाते अपनी बीबियाँ छोड़ दो यहाँ पे. See, imagine how the man will feel. And this is I think they should not go in the YouTube and all. Only I am telling you the factuals which had happened. And there are a number of things which I will not go into this. Or in spite of this, if you are talking of the human rights of a particular person who is giving this kind of injustice to other person, then there is something wrong. No, so that you have to see. Now, what does Armed Forces Special Power Act gives the armed forces? Firstly, you can stop anyone at any point. Secondly, if you are having ammunition or a weapon which you can fire at him without a strict magistrate order. Thirdly, you can search any premises if you feel that you find there is something, some ammunition, etc., is lying in that house. And if at all you have to be convicted in spite of this, then the sanction of the central government is required. That's all. There is nothing else to it. Now, if you don't give this, then there is a. Just tell me when I have time, 5 minutes when my time is. So these are the things which are there. So we operate in this, and from time to time, our own hierarchy, we as a senior officers or chief, the Supreme Court has given us guidelines in spite of enabling us that don't do this. If you apprehend a person, please give it to the police. Or if you want to, sometimes now, when the situation improves, he says, if you want to apprehend a person, then you tell the police first. Now, our colleague, Mr. Arvind is there, he will very well know. If I go for an operation, if the terrorists are there, I go to the police, a local police, we have got a number of sympathizers. I inform him that I am going for operation here and there. You can know the result of the operation. And therefore, I will not dwell into it. So there are number of things, number of impediments which actually hinder our operation. In spite of that, as we say, when you go into the boxing ring, your hands are tied behind the back. In spite of our hands being tied, we use our head and kill the terrorists. So those are the things. I say now, number of times, UN Human Rights Commission tells us they are draconian. Yes, there are a number of times there are incidents where you go out of the law, maybe. But in the army itself, there is a mechanism where punish the person very thoroughly. And there are a number of incidents we have punished the person. And I'll give the example of Machil encounter, where we felt a colonel of the Indian Army has done wrong. And the encounter was, and I feel that it was not correct. We had given him life imprisonment, Armed Forces Court. He went to the Supreme Court of India and got himself acquitted. So it is not the Armed Forces Special Power Act using agency. It is the Supreme Court of India. So as far as we are concerned, we have punished him. If something is wrong with there and so therefore there are a number of state human rights commission which actually lay a lot of wrong allegations as far as we are concerned. Then we are fighting for those allegations instead of fighting for against the terrorists doing our job. We have to keep on fighting this. Like I'll tell you, there are, again, not to be quoted, there are 27 cases against me personally, from major to lieutenant general, when I spent the whole time and none of them was true. None of them. But at the back of the mind, I always felt that suppose tomorrow I retire and Jammu and Kashmir government sends a warrant for me, I'll be handcuffed. There is nothing. Nobody is going to save me. No central government, no state government, nothing. And I am at the left at the mercy of the police. A J&K police who may have harbor some ill feelings against the armed forces. So we operate in this kind of phenomenon. And I'll give an example. These things are happening everywhere in the world. And I'm telling you with full conviction that Indian Army's track record is one of the best. We'll take the example US. In Vietnam War, there were 240,000 troops killed. And there were 647,000 of civilians killed. I was a United Nations observer in Angola, and I had happened to be in Rwanda. There was a genocide of Tutsis by the Hutus. 6 lakh people were killed. When the French forces were evacuating various people, when the Tutsis requested them, they did not evacuate them. Number of them just left the mercy of the Hutus to be hacked to death. If Pakistan is concerned, they just don't have anything armed forces special, but they have got something like that. But their vote is whatever they decide, they can give the punishment of hanging, everything by death, and there is no question asked. So if you compare with rest of the people, rest of the armies of the world, I think our army, we can proudly say, is the best track record in human rights. Now I will end my talk. There are a number of things actually which I can say, but I'll just use example. Now, there is an ambush party, and which is going from one place to another. In 1990, what is to happen? We could not move. There is no police, there is no justice. There is nobody is to come. Everything was in the hands of terrorists. And they said the Azad is just around the corner. Every house had a weapon. Every boy had gone and trained. When I asked the friend, why did you send your friend, son? He says, Saab, agar Azadi mil gaya, to bolenge tumne kya kiya? So therefore, I had to send my son and get a weapon. So this was the condition. There is no governance, nothing. It was only we used to move and we used to be fired upon. Every day there is to be encounter. And Indian Army lost 7,732 soldiers so far in Kashmir alone in insurgency operation. And there are 13,000 civilians killed. Now, yes, there are civilians killed because they had a weapon, and therefore most of them, some probably would have been in the crossfire, they have been killed. Many of these 13,000 are the ones who on their own will they have gone across and not return. So the APDP, Association of Parents of Displaced Persons, they quote this figure. And this, if you calculate and carry out analysis, you find that the excesses, I'm not talking others, excesses but armed forces are hardly any. I'm not saying they are not, but they are hardly any. Suppose there are 5 people and you are going, everyone is a no, somebody somewhere you can get a firearm. Now you find that chap is having a weapon. And when you go to catch him, he just hides the weapon. Now what do you do? मेरे पास तो कुछ नहीं है, मैं तो एक यहाँ पे citizen हूँ. Why are you troubling me? What do you do? One example I will give you. In 2013, I was in charge of entire South Kashmir, Pulwama, Anantnag, Shopian. And the information came to me that there is one white Maruti, there are 4 terrorists sitting and they are passing. So I immediately passed on, we have got a system of passing. So we passed the information that there are 4 terrorists coming in a white Maruti, stop it. So we have a system of stopping the vehicles on the road. So the party was there, they stopped, they told the vehicle to stop. And it was little dark. The vehicle did not stop. Just flew, sped away from there. So the next ambush party was passed that there are terrorists in this. So you fire. So they activated the ambush, fired at these people, killed all 4. They were all civilians. Now tell me whose mistake is this? If there would have been terrorists, they would have killed 10 more there. They did not stop. They were properly challenged. And then the ambush was. The blame came on the army. And we had to fight for 1 year as to prove ourselves how we were not wrong. Second example. I myself was there. We had cornered 3 terrorists. And they had hired this thing, they had killed one of the colleagues. And when they came face to face, all 3 of them threw the weapons. As we were trained, we are also having the weapons. Our finger on the trigger acted, and all 3 were killed. Now the thing came when they threw the weapons, firing to stop. How do I know that they're throwing the weapon or firing at me? It's face to face. Now, will you blame me or will you blame the terrorist? When we were took in front of the judge asked, Major sir, I was a major then, how do you know he's going to fire at you? So I was so frustrated. I said, you asked that terrorist whether he was supposed to fire at me. And if you would have fired at me, I wouldn't have been here in front of you. So there are ridiculous kinds of questions asked, and we had to defend ourselves in all this thing. And the atrocities. Now we talk about the Human Rights Commission of everyone, including the terrorists. I'm talking about the human rights of the soldiers. If the soldier, they say, okay, you're conscripted or you've chosen the profession, you're supposed to die. Fine. There are 4 of us who are operating, 4 young officers operating incognito. The way of operating. In the jungle, the various villagers lured them by false information and took them far away that there are terrorists in this. This 4 plus 1, 5 were there. They are surrounded by about 250 militants. They were captured. They are skinned alive. It was recorded, and the record was sent to us. So imagine our state of this. So, ladies and gentlemen, my time is up. There are a number of things I would like to take questions on this armed forces special plan, various things, especially with J&K. And I'm more than willing to share anything with you. Thank you. Jai Hind, Jai Bharat.
Thank you very much, sir. Thank you for analyzing the Armed Forces Special Powers Act in the context of Jammu and Kashmir and also allowing us to glean from your valuable experience. Thank you very much. It is now my privilege to introduce retired Assistant Commissioner of Police, Mr. Arvind Patil. Mr. Arvind Patil is a registered pro bono advocate at the Bar Council of Maharashtra and Goa. He's experienced in criminal investigation and was selected as one of the top 10 candidates through direct PS through MPSC exam. He was also the teacher and instructor at the Special Security Training School. He was a senior PI of the Special Branch in Thane City, ACP Special Branch 1, Special Branch in Pune City. It is an honor for us to have you here, sir, and we'd like to invite you to present your views on police administration and citizen grievances against police from your perspective.
Thank you. Madam and Honorable Mr. Ross. I am an officer from field, so I am not used to speak on any dais like, so please bear with me. And before I begin, General साहब आपने जो किस्सा बताया कि पुलिसच्या नादाला लागायचं नाही. So it reminds me, and I can't resist from sharing this with you. When I entered in the police department, coincidentally, it was Pune city only. That was my first posting at Paraskana police station. So there was a Havaldar. He was on the verge of retirement. So he told me, it's a real kissa. So he said, he was posted in fixed point in a choke, and one road from that choke was no entry from this side. So what to do for 12 hours duty? So just have a pastime. They started stopping that bicycle wala or any two-wheeler wala, this is no entry, don't go. So just have a pastime. So ek tatya, you know, there is an image of a real Punekar developed in the minds of public. The Punekar is always they are argumentative. They fight on legal points or whatever points, or any point. So a Tatya came on this bicycle. So this constable said, Tatya, no entry. But Tatya said, but daily I go this way only. I will never stop. Whatever, don't tell me, there's a boat. But that building, there I live, this is a yellow building. Very near from, don't tell me, Tatya. See, into bracket, including bicycles, can you read? So Tatya was frustrated. Tatya said, okay. Then Tatya turned back. And that police thought that now he is returning. He just turned back, cycle uchalli, lifted that bicycle. Now, I am a pedestrian, sir, and I can walk. So there was, both of them were speechless. And that man went his own way. Straight way. They were speechless. So, पुणेकरांच्या नादाला लागू नको असं आम्हाला म्हणजे आमच्या सुरुवातीला सांगण्यात आलं. Having said that joke, the point is police administration and our aspiration, and accordingly, if not fulfilled, then we have some grievances against police. I haven't seen any other state, but they say Maharashtra police is in a better position compared with any other states. So I have to believe. Now I am here not only as a police officer, now I am a citizen and a lawyer also. But let me tell you, while in service also, that citizen within was always alive. So my style of working always had conflict with the superiors also. Unfortunately, DCP madam hasn't come. she knows better. So administration in Maharashtra, I will be restricted to Maharashtra only, my state police. Basically, 1816, when you talk of police, the police still even today in India, the police is governed by the 1861 Act, this Police Act is called, Britishers time. Thereafter also there came many other enactments, even in 1996, then 1849, so on. But administration in the state, police administration is the hierarchy. Let us start from the DGP, the Director General of Police, is responsible for the whole state. Then at regional levels, there are Inspector Generals of region, like Kolhapur region or Konkan region. Then district SP, or where there are commissioners like Pune and Solapur. So there are commissioners. So the commissioner is also at some places holding the of the rank of DIG, Deputy Inspector General. And for the city like Pune, there are additional DG level. Next to additional DG is DG only. But then below that regional additional CP, for Pune there are two regions. There are additional CP. They are also the rank of DIG. Then DCP, like Madam Purnima Madam is the DCP of Zone 1. So there are 5 zones in the city now today. When I entered in the service, there were only two zones. But now Pune has developed, or rather expanded, let us say. So then comes divisional ACP. And I am that rank officer. I am not a higher officer. So I retired at the rank of ACP, Assistant Commissioner of Police, having control over 2, 3, 4, or 5 police stations. Then, so this much up to ACP down from the DGP. These are all supervisory posts. But the actual field work is at the level of the police station. The police station in charge is, nowadays they are having 2 in Pune, senior police inspector, and for his assistant there is inspector for crime. So it's the second. Then in Pune city, there are chowkis. So any citizen or any, let us say, victim, when he has to lodge a complaint, he goes to the police station, a top chowki. Then there is one Havaldar. He directs to police station if he goes to police chowki. It takes some time. Then if the cognizable offense is there, they will register an offense, and some other or the PI himself, they will investigate the crime. So this is administration, but the main part starts after any offense is registered. The supervisory officers are responsible for day-to-day supervision, guidance, and so then ACP is responsible for that. But nowadays, or in Maharashtra, it is seen that the superior officers' supervision is not up to the mark. That is my experience. And this gives birth or the rise to the complaints against police. So why we have grievance, and mostly you people be knowing that what kind of grievance firstly we have against police. what? Mainly, they are not taking cognizance of your complaint. A common man, he doesn't know what is cognizable case and what is non-cognizable case. But he goes to the police station with his grievance. So the response is very frustrating. Then he goes to PI, then goes to ACP. But as I said, the supervision is lacking altogether in the state level, state police. And this is not the case of Maharashtra state only, all over India, this problem was there. So Mr. Prakash Singh, he was the DG, he retired as DG in 1996. He was DGP, Uttar Pradesh, and I think Assam also. Then post his retirement, he went in directly in Supreme Court. He filed PIL, public interest litigation, and demanded, or sought some directions to the police in India. And then after 10 years, 2006, it was September only, 22nd September, I think it was given, the judgment was given. So 2006 May, Supreme Court gave directions, which that was a sensational judgment at that time, because Supreme Court mandated 7 reforms and also asked the government to complete it within reasonable time and also supervise whether they are complied or not. So in that 7, the main reforms the Supreme Court suggested was bifurcation of the police duty. Because it was observed by the court that police are not doing either duty properly. They are falling short of this duty as law and order. And because of law and order, their efficiency in investigating cases was affected. So what Supreme Court said was there should be 2 sections distinctly. One should look after the law and order, and the other section is solely responsible for controlling the prevention and detection of crime. But practically, in all over India, this has not been possible for any state. And later, it is still not possible because court of law, the staff is not sufficient, lacking staff also. So among the 7 reforms that Supreme Court suggested, the most important was for our grievances against police. That was establishment of police complaint authorities. So at the state level, we have here now in Mumbai, State Police Complaint Authority. And at district level, when instead of districts, in Maharashtra, there are police complaint authorities on divisional level. So we have here in Pune, Divisional Police Complaint Authority, DPCL. But it is interesting that this judgment came in 2006. So following that, the other states, one by one, they established, they formed this forum for public grievances. But Maharashtra was much late, and 2014 has to dawn for that. And here we have started first in Pune, then now they have started at Aurangabad also. So let it go. But police complaint authority that underlined, the Supreme Court underlined the need of that because they said for redressal of public grievances against police, there should be a separate forum. And for that purpose, Supreme Court insisted that this police complaint authorities at all district levels should be formed immediately. Some Kerala or Karnataka or even Union Territories like Pondicherry, they are having it since long. I mean, immediately after that. But we started it in 2014. And coincidentally, I happened to work at that police complaint authority post my retirement for 3 years as an investigation officer. So I have closely observed that if the superior officers, not my words, superior officer from the level of ACP, DCP and above, if they are diligent, they are vigilant, they are worthy, there will not be so much complaints at the police complaint authority. Police complaint authority, now at district level, that authority has power to inquire and they have civil court powers. The chairman of Divisional Police Complaint Authority is retired district judge. And at the state level police complaint authority, the chairman is High Court judge retired. So Mr. Taure, retired High Court judge, is now holding that post. So at district level or divisional level, your grievance, I mean, public grievances against police and police officer up to the rank of inspector only are triable. But if in your complaint some ACP or DYSP is involved, then the complaint has to be lodged with the state police complaint authority. But there is a crux. The crux is that after inquiry, if the police official is found guilty, the judgment comes from the police complaint authority only that we have found that this and is guilty of that. So now the ball is again in the court of police, superior officers. And now they have no voice. Once the judgment is given, it is up to the government. And they say now in the regulation I read, this is not obligatory for the government to accept the decision. So what is the use of that police complaint authority? I have seen in Pune some police officers who were held guilty by the police complaint authority. They found a trick. A senior police inspector of a police station, he was held guilty because he had registered an offense against a very reputed man. He was a broker, dealer, and that was maliciously registered, but it was vitiated legally, so he has got a good chance. So clearly he was held guilty. So this fellow went to High Court. High Court, what High Court did? High Court just, okay, High Court issued a stay. Stay on what? Stay on implementation of the police complaint authority judgment. And got it, showed it to the superior, I mean CP office, and they did nothing. like this. And he got retired peacefully, went home. So there is delay in implementation also. There are tricks they are being played. So these are the hindrances, and a common man has to fight with utmost, what is a strong mind and determination. Because everywhere there are hurdles, you get frustrated. In my case, it is not out of place to, I am telling you this. Even after my retirement, now that most of the police officers or constablers, they know me because I work in Pune city only. Near my house, there is a little hill, and on the top hilltop there is a Mangal Karyalaya, that is hall that marriages, wedding, other functions take place there. So at midnight, about 0:05, I woke up because of the bursting of firecrackers. So annoyed, I called the control room, police control room. They said, okay, we are sending marshal there. But that, it goes on about 10 minutes. That big, loud sound of firecrackers. So after that conversation with the control room, then I got that picture. I mean, in the got a little video clip of that bursting of firecrackers, and immediately sent to the police control room. Most of the people don't know that there is a WhatsApp number given by police commissioner for public. So you can send your complaints on the WhatsApp by pictures and videos, whatever. So immediately I received a reply that yes, instructions are given to the police station and police are sent there. So they took note of it. Next day when I went to lodge a complaint, they said we'll inquire it. I said okay. After 3-4 days, an officer of the rank of sub-inspector, he might have been directed by the PI to inquire into that, my complaint. So he sent me a letter that we inquired with 4 people. He gave their names. And it revealed that there's nothing like this happened on that night. So I was shocked. So why I say that, sir, accountability, Mr. Arvind, he was telling about accountability. So here the main question is of accountability and supervision, as I said. Then I went to the DCP. I said, sir, who these 4 people they inquired with was one, the owner of the hall, marriage, that Mangal Karyalaya. When you are asking the thief, did you steal this thing? Will he agree? He will say no. The second was watchman of that place. Third was the cook of that place in the servants' quarter he is living. And fourth was the person who had engaged the hall for a birthday party prior to that night. So he was not concerned at all. But just to negate my say, then I went to the DCP with the written complaint. And I explained him, sir, DCP, sir, So he read my application, and there were changes on his attitude and expressions. He put aside my application and said, okay, I will give it to ACP for inquiry. I said, sir, the ACP himself told not to do this because under Noise Pollution Act, the offense under section 15 is very serious. The provision is a 5 years imprisonment. And this act, according to Environment Protection Act, Madam, you may know Environment Protection Act, section 15. So that is to be investigated by a police officer not below the rank of DYSP. That means ACP. And just to avoid that, the superior officer of the rank of ACP gave wrong directions to the newly come PSI. And this way they avoided registering an office. Then myself, Arvind Patil, a retired police officer, now as a common citizen, knocked the door of Shippy. See, why I am telling you, because this is interlinking grievances of police and administration. Because of administration or that administrative flaws, there is a rise in police complaints. And because of, anyway, I went to CP. The CP forwarded down to the DCP again. The DCP was told by additional CP when we met, yeah, we are a retired police. There is an organization in Pune, retired police organization. So our chairman of our organization and myself, we went to the additional CP. The additional CP immediately called the concerned DCP and told that that Arvind Patil is a retired ACP and which complaint he has lodged, he has substance. Why don't you register an office? He said, okay, sir, I'll do it. But he did nothing. Then I told him, finally, I went to High Court. Under 482, I sought direction from the High Court. Then High Court gave direction to Zone DCP 5. Then 2 months back, that offense came to be registered after a period of 2 years and 4 months. And now, since that there is no video clip that is wiped out, that control room says we don't have that. But they said that prime officer, there is a case in your complaint. So they lodged the complaint and finally they finalized it with A classification that the accused cannot be traceable now. So the administrative hierarchy is not applying their mind. Their duty is to supervise. And the supervision should be participative supervision. So these things are there, which are responsible for the rise in public grievances. 90% complaints of the public are that their complaints are not taken cognizance of. Why they are not taken cognizance? Now, in 2006, madam, the decision, Lanita Kumari's decision came, and that Honorable Supreme Court has mandated that if the complaint discloses a cognizable offense, it should be registered immediately. And those police officers who fail to do that, they should be punished. Anyway, the time is over. Thank you for bearing with me. Thank you.
Thank you so much, sir, for sharing your experience from a law enforcement officer as well as a lawyer's point of view and deliberating on the question of police administration and citizens' grievances. You dealt with some issues, but also suggested some possible solutions, which would be great for us to take forward and discuss in our question and answer session as well. Just to indicate to the participants who have joined online, the chat has been enabled for you to put in any questions for now. It will soon be disabled. So if you have any questions so far that you would like to pose to the panelists, you can go ahead and do that now. Speaking of some solutions and a solution-oriented debate, we would like to now move on to discuss about police reform initiatives, impediments, and the way ahead. For this, we have Dr. Akshat Mehta. It is my privilege to introduce Dr. Akshat Mehta to this forum. Dr. Akshat Mehta is a University Dean and Associate Professor of the Rashtriya Raksha University. He's an Executive Council member of Police Academia Interaction Forum. He's a director of the School of Internal Security and Police Administration. With a double MA in Police Administration and Public Administration and a PhD in Public Administration, Dr. Mehta previously worked as an assistant professor in Police Administration at Punjab University. He's the first associate professor in Police Administration and head of department of the Police Administration Education. It is a privilege for us to have you join us online today, Dr. Akshat Mehta. A very warm welcome to you and over to you to discuss about police reform initiatives, impediments, and the way ahead.
Thank you so much, ma'am. It's a proud privilege to be part of this roundtable discussions which are taking place. And I have learned a lot actually by listening to the distinguished panelists, which as Professor Shashikala Gurpur mentioned in the morning, that 3 important reasons for having this roundtable conference. And one of it was to have the galaxy of illustrious eminent speakers out here. I won't count myself out there, but when I heard each one of you speaking out there and giving your perspective about the theme, which is very pertinent about police, security, rule of law, and human rights. Dr. A.K. Head Strauss is here, Professor Arvind Tiwari, sir, whom I've known for a number of years and admire a lot. Lieutenant General Rajendra Nibhorkar, sir. Just heard Arvind Patil ji. Look forward to hearing Advocate Nilima Vartak ma'am and Aparajita Mohanty ji, Dhanaji Jadhav ji, all my distinguished colleagues from the Symbiosis Law School, Pune, and all the participants who have taken their time out to be part of this roundtable. The entire nation is undergoing transformation in terms of how governance is to carry out its day-to-day activities. When all institutions of governance are transforming themselves, can police remain insulated from the winds of change which are flowing left, right, and center? Within that dimension, when we look back, we have seen that there is a backdrop which gets attached to Indian police. We go as far back as the first revolt of independence and then the subsequent attempt being made to have this structural and procedural architectural redesigning being undertaken by the Britishers. And in 1860, they had this committee, and based upon the recommendations of this first Indian Police Committee, they came out with Indian Police Act of 1861. Obviously, the entire design was not subject specific. It was not meant by taking into consideration how Indian citizens would benefit out of the architecture which was being laid down in 1861. Please remember, we were under a colonial scenario, and obviously the designs of the people who were ruling were altogether different. So it could not have been a very citizen-centric, citizen-friendly, responsive policing, which we would have got. Then came 1947, the tryst with, destiny, the midnight speech, the burst of optimism with which the entire nation was looking forward to a sea change in terms of how governance would come forth and how every possible institution of governance would be catering to the interest of citizens. It took us some time some probably years actually to be fully awakened about the need to bring about reforms in the manner in which police as an institution was to cater to its own citizens. There were certain attempts made in the post-independent India. We could refer to what took place in the early 1970s with Professor M.S. Kore Committee on Police Training. Professor Arvind Tiwari is here from Tata Institute of Social Science, and to have someone as eminent as Professor Gore laying down a roadmap for having a new architecture for training of policing was something which the country was looking forward to. We had a very phenomenal attempt made in 1977 in terms of National Police Commission, which between the years of 1979 to 1981 came out with 8 comprehensive reports to bring about total transformation as far as police in this country was concerned. There are limitations, there were constraints, there have been barriers, obstacles, impediments in the way certain aspects of police reforms were approached in the yesteryears. But to move forward, the advent of 21st century particularly saw a lot of movement. Right at the outset, we had Padmanabhaiya committee. Just prior to it, we had Julio Ribeiro committee trying to bring about certain changes, or at least suggest certain changes as far as policing is concerned. The Malimat committee on criminal justice as a whole. We had Police Act Drafting Committee being headed by former Attorney General Soli Sorabji, constituted in the year 2005, which came out with Model Police Act in 2006. These are some of the important initiatives taken after independence, and more so with the advent of 21st century. I was listening to Arvind Patil sir, and he was referring to a very landmark Supreme Court judgment of the year 2006, 22nd September to be precise, in Prakash Singh and others versus Union of India and others case, which had a churning for 10 long years actually, because courtesy of public interest litigation filed by Prakash Singh and N.K. Singh sirs, the Supreme Court started looking into the subject matter. It's again a food for thought that certain aspects which can be taken up by legislature and executive have to go all the way down to judiciary to be really brought to the spotlight, and some sense of justice would come forward. It's a cause of concern that the judicial activism is probably a response to slightly less active endeavors of those who are supposed to be carrying out their responsibility in a very carefully constructed balance of powers between legislature, executive, and judiciary. But nevertheless, this public interest litigation led to what we saw in terms of the 2006 judgment. I was listening very keenly to a couple of dimensions which Patil sir was laying down before us, including the dimension of separation of investigation and law and order. The need and necessity being felt that law and order is also specialized work, and you need a set of people to be focusing upon them. At the same time, investigation is a very specialized function, and you need a set of people focusing upon investigation throughout. It's very much pertinent for everyone who's involved in investigation to be updating one's skill sets on a continuous kind of a basis, because the technological advancements, the kind of forensic developments which would come forth has to be very well, not only understood, but applied by a set of people who would remain there for a substantial period of time. So with that kind of an intent, one of the directives of the Supreme Court judgment was a separation of investigation and law and order wings as far as policing in this nation is concerned. Patil sir mentioned about complaints authorities. When we have a complaint, we go to police. When we have a complaint against police, where to go? So in order to find an answer to that, Supreme Court came out with this particular directive of setting up a state police complaint authority and several district complaints authorities also. Some of these matters became sub judice, and one experience shared out here by Patil sir is a point in this regard. Very importantly, this judgment talked about stability of tenure to be given to the heads of the police organizations. So when you have DGP of a state, say Maharashtra or Gujarat, or for that matter, Punjab, you need to provide a stable tenure after a panel which selects them through a mechanism which is well laid down, and where the role of a Union Public Service Commission would also come. Now, this is expected to provide the right kind of a person to lead the entire police force in a state, and subsequently to ensure that the proverbial Damocles sword is not hanging by the neck of the officer who wishes to carry out day in and day out the responsibilities for which the officer has been selected. One example in the northern India is that the frequent changes in the DGPs of that particular state has almost demoralized the force also, in terms of the DGP having to proceed on leave, wishing to go on deputation, coming back, being given a different kind of a responsibility. I mean, the way some of the political leadership are handling these kind of appointments is a cause of concern, despite Supreme Court reminding us around 16 years ago. 22nd September is approaching very soon. So an architecture, a new architecture which was being laid down by the Honorable Supreme Court is something which still has to translate clearly at the ground. And this is a slightly a cause of concern also. Similarly, the judgment also talked about a minimum tenure to be provided to all officers on operational duties. So it meant even an SHO in a police station has to be protected. A person who's in charge of a range or a zone needs to be protected, and so would be a commissionerate system also. Now, the point out here is, again, if I have been given a charge of a unit, say a police station, you want to hold me accountable for my performance, please give me a subsistent and substantial time to understand the nitty-gritty of that place and then hold me accountable. If I just go out there without knowing my term, without knowing how much time I have to lay down my ideas, which I wish to implement out there, I mean, it won't work actually. So insulation from political interference is something which becomes very pertinent. I'm not talking about political mentorship or guidance. The entire structure, the constitutional scheme of things have been designed where the political mentorship and guidance is essential. People who get into the legislature are those who have been elected by the will of the people, and that would always be, I mean, superseding, and everything else should become subservient. But I'm only referring to the day-to-day political interference, which has the potential to disrupt the manner in which the institutions of governance have been designed to discharge their responsibilities. Madam Shashikala mentioned in the morning about rule of law. I'm reminded of David H. Pele, who has done phenomenal work in several nations, including in India, for policing. And he particularly talked about the decades of 1970s and 80s of Indian police structure and said that there is a fear that decline in the rule of law is taking place. And we all need to join our hands together to prevent that kind of an anomaly becoming some kind of a system in times to come. He was referring to the internal emergency, then the National Police Commission being constituted, and subsequently what we saw in terms of the police reforms not being implemented in its true sense was something which people like David H. Pele have been highlighting, and we need to be always concerned about those dimensions. To take a clue from the welcome address of Professor Gurpur, when she mentioned about, I mean, the force element of policing, the manner in which it has operated in a couple of places, she referred to 300 odd case studies being undertaken in Northeast and other places where certain powers and discretions being given to the police, and how do we balance this discretion vis-a-vis the responsibilities and the constitutional mechanisms being laid down. It's very important, friends, to have a look over second administrative reforms commissions fifth report. This report brought out in the year 2007, and it's titled Public Order, Justice for Each and Peace for All, has very important lessons for all of us to learn. It touches upon the character of the police and states that changing the character of the police from a force meant to enforce the writ of the state to a service meant to secure the lives and liberty and constitutional freedoms of the citizens in a free and democratic country. It talks about police stations becoming service centers rather than becoming power centers. Now, this is where the entire, transformation in terms of ethos of police lies. To also refer to the Model Police Act of 2006, brought out by Police Act Drafting Committee in 2006, which talks about an entire chapter being added on social responsibilities of police. It talks about powers and responsibilities, but a very, very specific element has been added about social responsibilities of police to its citizens. When I talk about this new grammar, lexicon, terminologies of service, becoming service center, having the ethos of service right there at the top, trying to look into working with the people rather than an idea of working over the people, we are talking in terms of transforming the entire idea of what police architecture was designed in 1860-61 to what it was meant to be post 1947, 15 January or 26th January 1950. But more importantly, in the 21st century, as I said, when entire governance is trying to become answerable to people, trying to become citizen-centric, citizen-friendly, citizen-responsive, the entire movement from governance to good governance, towards which all institutions are trying their level best to work their way through. Police has the onus, police has the responsibility to move towards that kind of a dimension itself. And that's why some of the dimensions which have been laid down in 2006 remain as pertinent today as perhaps ever. I have a quotation which I keep on referring to in many of my classes, which says, and I start the quote, "The police is far from efficient, it is defective in training, and the organization is inadequately supervised. It is generally regarded as corrupt and oppressive, and it has failed to secure the cordial cooperation of the people." When I ask in my classes that, can you tell me from where I would have taken this quote, which year? Some people would go 10 years ago, some say, perhaps you're talking about the present. In fact, this is a quote which has been taken from a pre-independent police reform commission of 1902-03 called Fraser Commission. It sometimes hurts, pains. It leads us to, reiterate our resolve to work our way together to remove all these fallacies and say that so many years down the line, we are still grappling with some elements of what has been quoted in 1902-03. Now, enough of, lamenting about whatever we might have missed in terms of the past couple of decades. But there are certain limitations which have led us to be where we are. There is an issue of center-state relations because police is a state subject. The Constitution, the 7th schedule, list 2, does point out clearly that public order and police and certain elements are there in the state list. So several of the state governments would be very much wary whenever center would wish to bring about police reforms. There are elements of political class not appreciating the need for really pushing the agenda of police reforms. We, the people of India, mentioned in the preamble, are also to be blamed for not really pushing for the agenda of police reforms whenever the electoral process comes closer, and it is coming closer in several of our states. There are vested interests who are probably benefiting out of it. There are financial limitations which sometimes come in the way of pushing for this very agenda. And the way the orientation and the evaluation of police is taken in terms of statistics. Last year in September, if in a police station, X amount of crimes have taken place, next year in September, the X should not rise phenomenally. It should be either X minus 1 or X plus 1. So that kind of a statistical management of crime data, which probably has been how management has allowed people to work, is also very much responsible for what has happened. To add to the concerns is a public perception about police functioning, which unfortunately many of us have not been able to realistically put forth before everyone out there, and the self-perception of a police personnel also, which has added on to all the constraints and limitations which I can put forth. There is a way ahead, as the title of my discourse would mention. The way ahead starts with our focus upon the structural, procedural, and behavioral aspects of policing. There are elements which have been very well laid down in the Prakash Singh judgment. There are aspects of gender sensitivity and human rights sensitivity, those service orientation, sensitivity, orientation, and ethos, which have been laid down in the Model Police Act of 2006 and subsequently in the legislations which several state governments have come out with. I know, some of the things at the ground may not look that well right now, but please bear in mind, from 1861 to 2006, we had one kind of an architecture and slight attempts being made here and there. So we have an inertia, if I'm allowed to use this term, of around 145 years behind us. And subsequently, it's been only 15 plus years of a new wind of change being set into place, where some experiments are taking shape in and around us. Many of these things would require a lot of support from community and public. That is why all the community policing initiatives taken in several states, including in Maharashtra and other places, needs to be brought out and documented. Madam Shashikala mentioned about best practices and lessons which we can learn from one another. So within that, I believe that the duty of several institutions, particularly someone who is representing Rashtriya Raksha University, which is the only university created for this kind of an endeavor. Just for the information of my colleagues out here, we come under Ministry of Home Affairs, Government of India. We have been created to really provide solutions to several of the challenges which have been laid down before the nation, obviously in coordination with, in collaboration with all right-minded institutions and group of people within the country and outside the country. And we are working towards bringing about academia and police together also. We have a police academy interaction forum wherein universities and police organization have joined hands together. Another important aspect of bringing about police reforms, that I cannot remain insulated in my academia world without involving police personnel on a more substantial basis and vice versa. And the entire country has seen defense and strategic studies and other thought processes taking deep roots. For some strange reasons, we ignored academic research endeavors in terms of policing. I think the time had come. Some of us have been created for that very purpose. We owe it to our nation for bringing about and sustaining this culture of police reforms. Many of my friends and colleagues in police are doing phenomenal services at the call of their, not only their duty, but putting their lives also at stake. I think by acknowledging their true contribution and also by bringing sensitization, wish our expectations from the public side towards them, we can really create a good ecosystem. I think Symbiosis has done a phenomenal work of bringing about different stakeholders, but each with a great potential to work together and bring about this phenomenal thought process of initiating and then sustaining police reforms in this country. I'll take up more such ideas when question and answer sessions would come. Thank you for providing me with this opportunity and having me here. I look forward to your questions also, and hopefully some answers which I would have also. Thank you.
Thanks, sir. Thank you for that very detailed and insightful deliberation on the impediments to reforms. But a lot of topics that you had touched upon, like the separation of law and order and investigation and insulation from political interference, etc., are things that are solution-oriented, which requires further discussion, maybe more academia-police interaction as well. So thank you very much for your insights. We have been now joined by Ms. Purna Gaikwad, DCP of Pune. Very warm welcome to you, ma'am. So I would like to invite Dr. Shashikara Gurur, ma'am, to kindly facilitate DCP, ma'am. Moving on with our discussion, as Dr. Akshat Mehta had brought out the discussion on the separation of law and order and investigation, we're going to discuss now about the rights of investigation and their linkage with human rights. So in order to deliberate with us on this topic, we have Advocate Neelama Vartak, former government leader, and it is my honor to introduce ma'am. With an MA in psychology and LLB and LLM from the University of Pune, Advocate Neelama Vartak has been practicing as an advocate at the District Court of Pune since 1979. Since 1983, she worked as a part-time lecturer in the ILS Law College, Pune University, Symbiosis Law College, and Marathwada Law College, Pune University. From 1986 to 2012, she worked as a prosecutor in the District and Sessions Court at Pune, and also working as special prosecutor for the state in matters of anti-corruption, NCOC Act. During this period, she has conducted several civil, criminal, as well as matrimonial matters. We're very honored to have you, ma'am. A very warm welcome to you.
Good afternoon, everybody. Honorable Dr. Shashikala, all the dignitaries on the dais, and all the participants, physical as well as online. The subject given to me is relating to the police investigation. We have heard much about the police, policing, and police reforms. So far as the investigation part is concerned, I would like to discuss with you in 3 angles because I am a part of all these 3 angles. As a professor of CRPC, I have gone through these aspects of the investigation and trial. As a prosecutor, I have seen the investigation from prosecution point of view, and as an advocate, the defense advocate, I have seen this same aspect from the defense point of view. So far as this particular aspect of investigation, police investigation is concerned, police investigation and human rights. So why these 2 topics are together, I don't know. So far as this police human rights aspect is concerned, Lieutenant General Rajendra ji has referred to it with little displeasure. But I would like to bring before you all that so far as this particular aspect of human right is concerned, it is very important aspect so far as the police investigation and the trial is concerned. The displeasure is there, that is because of the delay in the investigations and the trials. The human right aspect is there, and we should not displease with it only because of human rights, certain persons are not given punishments, even though the police officers have taken much pains on the investigating into the same. If you see the provisions of Criminal Procedure Code, you will find that there are 2 different sections in Criminal Procedure Code, which deals with the aspect of investigation on one side, and it deals with the aspect of the trial on the other side. But they are not watertight compartments. It is not the differentiating line in between the two. You will see that when the FIR is registered, that is the starting point so far as the registration of the crime is concerned. And the law doesn't say that there is no scope for the judicial point of view. There is no scope so far as the investigation or the appreciation of investigation is concerned. One thing is certain, that investigation is within the total power of the investigating officer, that is the police machinery. And in many judgments also, and the law is also very much clear that there is no interference of even the judiciary. Very rarely judiciary will interfere so far as the investigation power is concerned. But generally, there is no interference of the judiciary so far as the investigation is concerned. If it is so, then where there is a scope of investigation and what are the rights of the investigating agency? That is very important aspect. When you start with the investigation, you all are from the legal field. So I will not tell you the various provisions of law on this point. But so far as the constitutional rights are concerned, Constitution has dealt with the fundamental rights of the accused persons. And according to that fundamental rights, there are certain rights given to the accused persons. There are so many such type of rights, right against double jeopardy, right against the other types of exploitation so far as the accused persons are concerned. But the very important right so far as the accused person is concerned is that after the arrest, within the period of 24 hours, he must be produced before the magistrate. That is very important aspect. So this is the first stage where the investigating officer has right of investigation. Within 24 hours, there is no interference, there is no reference so far as the courts are concerned. Thereafter, the next stage comes. So the police officers are very well aware that you go along with the report, remand report, which is popularly called. And in that remand report, you have to, according to the very object of the criminal procedure code, you have to satisfy the court why you need police custody. The right of a person, right of freedom is the fundamental right. It is the priority right. And that is why the care is taken by the law that the person should not be deprived of his right of liberty unless the procedure is established. So the next stage, after 24 hours, thereafter, the next stage comes that you go before the court, you ask for the custody of a person, and then popularly it is called as a custodial investigation. So this custodial investigation, what are the rights so far as the police officers are concerned? Nowhere, so far as the investigation techniques are concerned, nowhere such techniques are mentioned. It is the conscious need, necessity, and the architecture of every person, the investigating officer, how he wants to investigate, in what way he wants to investigate a particular problem before him. There are so many types of all offenses under section 302 cannot be investigated in the same way. Nowhere the law says that immediately after the FIR is registered, the person should be arrested. The police officers like Patil Sahib will agree with me, because he is now retired police officer, and in those days there was no necessity felt by the police officers to immediately arrest a person. Nowadays, because of the social media, people feel that this person against whom the offense is registered, he should be arrested immediately. So necessity of arresting a person and necessity of the custodial investigation, these two things are very important things so far as the investigation techniques are concerned. So when to arrest a person is also a right of the investigating officer. He is supposed to exercise the right of investigation in the same way. Many times you will come to know that sometimes it may happen that the person is arrested, and when the person is arrested, up to certain point, the investigation is complete, but the custody of that person is necessary for the further investigation, which may take place after some time. So the police officer will reserve his right of custody in such case also. So far as the custodial investigation aspect is concerned, you all are aware that there are certain limits so far as the custody is concerned. How many days you can have a custodial investigation, that is mentioned in the act. So it is the law which doesn't permit you to have a custody of the police of the accused person after that particular period. So you have to decide, the police officer must decide how to investigate, in what way he should investigate, and what techniques he should adopt so far as the investigation part is concerned. So far as this particular aspect is concerned, so if you apply the principle of human rights within that, so the human rights are also there so far as the investigating officer's rights are concerned, and so far as the rights of the accused are concerned. Firstly, we will deal with the rights of the accused. So while dealing with the rights of accused, why there is a provision of medical examination of the accused person. This medical examination of accused person is at 2 stages. Immediately when you arrest a person, before you bring him before the court, that is within the 24 hours period, the person's medical examination is necessary. So medical examination of a person is done before he is produced before the court. Thereafter, the police custody is given. So suppose the person, the accused person is complaining about some ill treatment at the hands of the investigating officer, he may ask for the medical examination, or the magistrate also can send him for the medical examination. So at the request of the accused person, or the court also can send him for medical examination. Why this provision is there? It is there, and it has in 2 ways. Sometimes the accused may falsely complain that I was beaten by the police officer for the purpose of this particular thing, for the purpose of giving some confessional statement or whatever the case may be. So if he complains in that way, to prove that it is a false complaint, that is in the interest of the investigating officer, this medical examination is necessary. When he says that I was beaten, and if his medical examination is taken, that thing also proved by the medical examination. So this aspect of the human right is there so far as this particular aspect of investigation is concerned. Another important aspect so far as the investigation techniques are concerned, we all are aware as the law students that especially so far as the law of confession is concerned, confession is very important so far as criminal trials are concerned. Confession, if you go through the provisions of the Indian Evidence Act, confession is nowhere defined in the act. But still it forms very important place so far as the criminal trials are concerned. And when the confession is properly recorded, properly brought before the court, there can be conviction based on the confession. So this is the importance so far as confession is concerned. So to bring about this aspect of confession recorded under section 164 of Criminal Procedure Code. Confession given before certain authorities, confession given before some person, before police officer, the confession has no importance. However, there is section 27 of Indian Evidence Act, which gives little importance so far as the confessional aspect is concerned. So if you consider this particular aspect in the rights of investigation, you have to include all such type of things so far as the law permits you to investigate into that. So far as the other aspect of investigation is concerned, that many speakers have referred to the various investigating authorities, especially the state police and the central police and the other police authorities also. In the previous time, we were aware only about the state police so far as the investigation of crime is concerned, and at the most CID. But nowadays, there are so many other machineries which are involved, the central government machineries which are involved in the investigation of crime, and they are very much active. So far as these aspects are concerned, in many occasions, in many cases, we have come across the conflicts between the state investigating authorities, that is the state police, and the central police. Not only that, there are some cases where the central police goes to the extent of filing FIR or including certain investigating persons into the same FIR which is under investigation before them. So I don't want to say that they should not do it. If necessary, the person's involvement in the crime is necessary, that can be done, no doubt of it. However, there are other ways also. The departmental inquiries are there, or the other ways are also there, or independently, there can be FIR against that police officer so far as negligence of the investigation or whatever the case may be. That aspect is concerned. So if you see from this point of view, the human rights of the police officers are also there. And in most of these cases, if you really have analysis of these type of offenses where the police officers are involved as the accused persons in certain, that may be the serious offenses like 302 of IPC or 376 or something like that. So there may be such type of offenses. If you see the path of it, then that the particular FIR which was under investigation before a particular police officer, and when that particular police officer becomes the accused in that case, then the whole focus of the case will be on that person as accused, and the main case which was before investigation, which was in the FIR, that is lost. That is, most of the times we will come across such type of investigations and such types of cases. There are cases in Pune court which are going on, means I am not saying about pendency, but the cases started before 15 years are still going on. There are so many cases. What is the use of it? That, sir, you have referred to the case where you said that we have investigated it, and because of human rights, the Supreme Court says that there is nothing in this particular case. Why it happens? The main reason is that of delay. So this delayed aspect, maybe who is responsible for this delay aspect, we are not today on that point. Sometimes, if necessary, we will discuss that issue also. I don't want to take this subject to that end. But this is the one of the very important reason. And then one fine morning, it is said that the thing is over. So it should not happen. That is why we have to take precaution so far as these types of investigation matters are concerned. You have also referred to the special powers given to the armed forces and the such other persons in that case. My submission so far as this particular aspect is concerned, I have come across, I want to refer to this very particularly because I have come across one agitations which was going on for a very long time in between the areas of Assam and these 9 sisters countries are concerned. And in that area, one leader, according to my what I remember, that her name was Sharmila Irom. She was agitating against these special powers so far as given to the military persons are concerned. And her say was that there are so many cases where we have find that the soldiers, they commit rape on the local girls and then they are not given punishment. So these special powers have nothing to do. So far as such offences are concerned, they were well within the power of the police officers so far as that particular states or union territories, whatever the case may be, they were concerned. So it has nothing to do with that. I don't know. And there may be such incidences, where the persons are not convicted. But it has nothing to do so far as this Special Powers Act is concerned. I have listened to one speech from this group where it was held in the Shivajinagar court area only, where they stated that we are not part of India because in the national anthem, Jana Gana Mana, she told me that what is stated, Punjab, Sindh, Gujarat, Maratha. So where is mention of our state in that? So I said that what is Dravida Utkala? Dravid means what? There is no mention of Kerala. There is no mention of Tamil Nadu. So in Dravid, all these states are included. So that doesn't mean that is how these types of agitations are carried out. So far as these aspects are concerned, we must be aware about it. The human rights, we must be taken care of. However, that doesn't mean that it is not important aspect so far as the law is concerned. Thank you very much for giving me opportunity of addressing before you all. Thank you very much.
Thanks for dealing technically with those questions and issues that are surrounding investigation, rights of investigation and other allied rights. Thank you very much. For the final speaker of the roundtable, we are honored to have in our midst Ms. Purnima Zaikwar, DCP Zone 3 Pune. With the MA in History and MBA in Cooperative Business Development, the current Deputy Commissioner of Police of Zone 3 Pune, Ms. Purnima Zaikwar, she previously worked as the Commandant in State Reserve Police Force, Navi Mumbai Group 11, SRPF in 2016. While working as the Deputy Commissioner of Police in Zone 3 Pune City from the year 2019, she was involved in corona preventive measures and relief work that was carried out by conducting a special campaign in the Parvati Darshan, Janta Vasahat and allied slum areas during the corona period with the help of special police officers, including police officers and police enforcers. She was involved in special action that was taken to send many laborers and workers to their hometowns by collecting the information of the laborers and workers from outside the district as well as within the district. She has done a lot of work with respect to the police enforcement, and we would like her to come and speak on the topic of field urban policing. A very warm welcome to you, ma'am. I invite you to come and speak.
Good afternoon, ladies and gentlemen. Respected dais, Professor Shashikala Gurpur, Madam, Dr. Ikhad Stross, sir, and the members of the panel that are here. Warm good afternoon to you here from this rainy Pune monsoon that we are experiencing. I'm sorry that I came in late for this discussion today. I missed a lot of important points here, but I'm also glad that I came in spite of, the institute just got to me yesterday and I had to adjust a lot of things in order to be here. But I'm glad I'm here is because in this entire discourse is what I'm guessing. A lot of it was said at a very public policy level, at a very in the level of philosophy, in the level of what is out there in words. But what we are doing out here in the field, I think there is a lot of dichotomy between the perception of what can be and what is actually happening. Till now, I have seen, especially with, I got to hear a lot of Dr. Akshat Mehta's discourse here and also Vartak ma'am. I believe that there is a perception in the academia that there is a lot of gap between the reform and what can be and what could be and what should be and actually what is happening. So I'm very happy that I can come here and represent my own experience and viewpoint as to this dichotomy that people think here, especially the students. And to tell you that, and I'm happy to represent this, that there is very, very little gap in terms of what we are practicing in the field with what is enunciated in all these other forums like police reforms and academia discourses. I will not get into each point, but I will broadly touch upon what actually is happening at field level, and then I will state my point. I will let it out to the house to the open house, saying that this is where we would like the academia to step in and maybe get together all these field practices that are there and convince the lawmakers, the people who are in the legislative bodies, that there is this can be and there is this is on the ground, and all this is can be assimilated into going further on a few workable things. And what are those workable things? I will put my case for that. One of the first things that we are talking about here is that although there is no functional specialization at the field level with respect to policing duties, at our own level, we are doing our best to wear various caps. What I'm doing at field level, I'll tell you. My sanction strength for my zone is around 1,000 policemen. Okay, but at right now, for my disposal, for my daily duties, I'm giving you very practical issues that I'm dealing with here. 600 policemen. With that 600 policemen at the field level, we have their weekly offs, which are now being made compulsory. We have an 8-hour work day for women, that has to women personnel that now we are enforcing very strictly at ground level. We are having a 12-hour work day, which we are enforcing for all the other personnel. So there is absolutely no let go on that. Earlier, these things were not defined. These things did not have accountability. But right now, every person who's working in the field knows that he or she is entitled to an 8-hour day or a 12-hour day. And we have to manage the entire, sorry for that. Can you just press stop? Stop. Yeah. So that is the one limitation that we are working with, is that we are working to almost half my capacity. Given that the needs of urban policing, as you know, are varied. So I'll tell you in short, in 2 seconds, how the police station is organized and how our duties are organized. We do at the police station level intelligence collection in the form of the local intelligence branch. We do detection in the form of a detection branch. We do prosecution. There is a prosecution wing, which deals with the day-to-day cases where we are bringing in witnesses, telling them, tutoring them, taking them, going with them through the case. Then we are responsible of giving them to the court all the prosecution duties, including summons and warrant, which again we are responsible for execution. Then we are doing law and order. We are doing a big part of our duty we are doing it. And unlike what the local perception is, 90% of our day is occupied with service. Dr. Akshat Mehta has said that we should be changing this orientation from power center to being a service center. I'm very happy to share with you that already at field level in India, in 99% of the cases, be it urban policing or rural policing sub-centers, the fulcrum is the person. And all our policies at the police station level are oriented towards service goal. So unlike the popular perception that we are at the police station, or the person at the police station is subservient to the political boss, it's subservient to ex-boss, that is not the case in urban policing in India right now. The citizen has taken the center stage. And we have a lot of policies, in place that are oriented towards responding to this kind of a changed, so to say, role. So what we are doing in Pune is that we have a service excellence and victim assistance center. We have a Bharosa cell wherein the citizen can walk in. His or her complaint will be taken, the photograph is taken, details are entered into a tab we have given at the police station. The complaint is recorded there, it is assigned to a person, and the person again knows that who it is assigned to and where he or she can take the follow-up from. Having done this procedural requirement, we are again bound by some of the Supreme Court judgments. One of them being the Lalita Kumari judgment, which says that every application that comes, although application inquiry is not a policing job, it is nowhere mentioned in CRPC that there should be an application inquiry. What is mentioned is that person coming to you, there is an offense, it is either cognizable or it is a non-cognizable offense. We are empowered to only register a cognizable or non-cognizable offense. But what has happened is, due to the huge population increase, again, I was telling you, for a 600 population, 600 personnel for my level, what is the guess that the population I'm dealing with in my zone? Any guesses? 30 lakhs? I am dealing with a population of almost 25 lakhs. So I'm doing one police station, 6 lakhs to 7 lakhs. So I'm having a personnel of 70 to 75 people who are dealing with a population of 5 to 6 lakh people. And we are doing this, fulfilling our multi-dimensional duties. As I mentioned, the police station will have a local intelligence branch, it will have an ATV, and I cannot assign an intelligence guy a law and order duty, because the minute he goes away from it, I'm losing out on intelligence from the field, which again is a very important part of my duty. I cannot take the anti-terrorist branch guy and ask him to do investigation, because dummy and decoy operation is a very time-consuming process. And I have to do it. We have to go to this thing of high footfall area, high footfall establishment, is do a dummy and decoy operation, which takes at least 2 to 3 hours, and then come back from there. So you cannot assign any other, and we have vital installations to look after in our anti-terrorist operations. But at the same time, a lot of our initiatives which are people-friendly, which are for the people, especially in urban policing and especially in Pune city, one I mentioned is the Seva. Second I mentioned is the Bharosa cell. Third, we have a police kaka and a police didi. Sir kaka is an uncle and didi is a sister. So what we do is we have in every police station a police kaka and a police didi who are entitled, who not entitled, who are given the duty of visiting every school in their jurisdiction and giving out information to students about their safety. So we have a police kaka, police didi talking about good touch, bad touch, telling them traffic rules, telling them that they have accessible to psychological counselings. So this is a part of a structure. This is a structural arrangement we have made within the institution. So it's not something that is that is an exigency of fancy of one particular person in power. Then we have Damini marshals who are given a bike and who are given the duty of patrolling the schools and colleges, especially when they are the off hours coming, when they are going home, so that we ensure that the girls are not eve teasing doesn't happen. The girls' safety is ensured. Children are not kidnapped and all that. And apart from that, what I am doing in my zone is I have declared all my 6 police stations as child-friendly police stations. The Juvenile Justice Act has a certain structural things, what would you say, requirements that are needed to be in place in order for you to be a child-friendly police station. So one of the requirement is having a child-friendly place, a space. So within that, I'm dealing in my zone, I'm dealing with juvenile delinquency, and I'm also dealing with children in need of care and protection, which are the 2 main aspects of Juvenile Justice Act, dealing with juvenile delinquency. Because since what has happened in urban areas today, sir, is that especially in India, is that the land is of primacy, especially in urban areas. And a lot of gangsterism around the land is on the rise. So what has happened is the older gang members or the gang leaders have graduated, so to say, to white collar crimes, and they are because poverty is so much, and because there are regular recruits from the slum areas, a lot of delinquents are being engaged for their work of extortion, for their work of taking up land and all that kind of activities that they have in mind. So instead of dealing with those people, there is a different way to deal with them. Juvenile delinquency in an urban area is again a very, very pressing problem. And having recognized that, I have around 350 juvenile delinquents in a year that we are dealing with. So we recognize that problem, and there is a provision in law. I just bridged that gap, and I said all 6 police stations in my zone will be child-friendly police stations. Kerala, as a state, is a child-friendly police station state, but nowhere in India an entire zone has all its police stations as child-friendly police stations. Through these child-friendly police stations, what we are doing is we are doing an engagement with the community. My special juvenile police unit is going into the community, interacting with parents, interacting with children. We have conducted surveys. Again, it is not my forte, but I'm very happy to say that I'm taking help of a lot of institutions like you. What we are doing is we are requesting institutions, and we're saying we need to have a database, kindly conduct a survey. So they are giving us their students, and based on that, so they build a questionnaire. So they get into this habit of having a questionnaire for a data survey. So this kind of inter-institutional engagement, the police is doing in Pune. I'm doing at my level, I know that. And because of that, we have a nice database now on which to work on. So what is it? What are the areas in which juvenile delinquents frequent? What are the things that get them into juvenile delinquency? Who are those people who are actually, looking at them as recruits? So all that database is ready, and now we are in that mode where we just need to go and intervene. And that we're doing. I'm happy to say with this initiative, in the past 1 year, ma'am, we have rehabilitated 27 juvenile delinquents who had serious offenses like attempt to murder and murder against them. We tied up with institutions which gave them vocational training, and 27 of those children who had serious crimes registered against them are now rehabilitated into the society. They are working in institutions, in factories in PCMC and Pune area. Another initiative that I took at my level is I did this Pune Police Psychological Wellbeing Project. In this project, corruption, as everybody has stated, is a problem that you perceive that we are victims of corruption, or we are the perpetrators of corrupt system. In order to understand this at the very base, at a very basic level, I said, who is the person who's representing me, and who is my public face? My public face is my constable on the road. That constable takes a takeaway salary of 35,000 to 40,000 max. Sab kuch cut karke. So when he's taking a 35 to 40,000 salary home, and he has to live, not everybody can be provided with a quarter. Not everybody is provided with free schooling. Not everybody is provided with rations, unlike army. Army or armed forces takes very good care of its personnel. That kind of care in this, what do I mean by care? I mean assured housing, assured schooling, assured ration. Okay, if these things are taken care of, my man will be able to live with 35 or 40,000 salary. But is that the case? That's not the case. He has to live in a rented accommodation. He has to send his children to schools which necessarily do not have free education for police personnel. So he has to pay the requisite fees and all the other urban demands. So when I said that he or she is my face at the public level, I need to change the way he or she looks at things. And how can that be done? By bringing about a change in your own perception of what your needs can be. You bring in, you start thinking about your own needs. What is your need and how much can you need? If that analysis, if that understanding can come within that person, he is in a position to say no to a few things that are unnecessary. And that can only happen when he introspects. He or she is given but that introspection can happen when he has dealt with the stress, when he has dealt with the frustrations. So how will we do that? How will we peel away all those layers of response and then get to him or her at the heart is what I thought of. And we said that he must have a dialogue with himself. In order to have a dialogue with himself, I need to provide him an institution with which who will help him to have a dialogue with him. So with this end in mind, I conceived this Pune Police Psychological Wellbeing Project. And I said, look, there are these structural things which I am not in a position to change. I cannot change his working condition. I cannot change his or her salary structure. But what I can do is I can provide him some outside help. So what I did is I engaged with few institutions. I engaged with corporate institutions. I requested them through CSR to fund these institutions, to give me counselors at police station level who will be sitting in the police station twice a week without any barriers in timing, because we don't have working timings, because we're doing multifarious things at the same time. So now, right now in zone 3, in my zone, I have for the past 1 year, I have counselors who come and sit in police stations, in-house counseling. And where there was a lot of resistance to that because, they didn't want to be tagged as taking psychological help. Because all this triggers mental health is something that we as citizens ignore, and we ignore it more for the police because we think he should not have a personal life. He is not capable of being a human being. He just has to respond. But no, he is a human being at the end of the day. There are issues that he has to deal with internally, and then he has to respond effectively. If he is not sorted inside, I don't know how he is going to respond within the bounds of rule of law and all that. So we went about it in a very systematic way. We had sharing circles, we ascertained their needs. So it looked as if it came from them. And through those needs, we decided that we're going to deal with it at two levels. One is to bring about whatever structural change we can at the police station level. If any one of you has had the misfortune, and I'm saying this with responsibility, if any one of you has had the misfortune to visit a police station, the first thing that will greet you is the stench, the smell. So you must take this opportunity to visit a police station in India in order to get how things work at the field level. So the first thing that greets you is the stench. So I said, it's my responsibility to make the workplace happy for my person to come. And stench is not the first thing that should greet him. So we reached out to corporates and we said, please do something, give me funds so that we can refurbish our toilets, and tied up with them for a year or two of maintenance contracts. We are not given cleanliness personnel to clean up our toilets. We should be cleaning up our own toilets. I am all with that philosophy, but all these other multifarious duties, if I have to give him a jhadu to clean up a toilet, he's not going to be motivated, he or she. So we said that one of the things is that. Second thing is restrooms for our women, and feeding rooms for lactating mothers, and restrooms for my personnel. So the cramped place in cities, does not give us this kind of thing, but yet we have kept one room aside, which we designated as restrooms, and that is a huge dent in their things. And the another thing that we wanted was showers and changing rooms at police station, because 8 hours and 12 hours for me, and this is off the record, is still something on paper. Okay, we go much beyond that. When, especially in Ganpati, I'm coming back from a duty of, I was standing for 37 hours. 37 hours with just 1 hour break for my daily needs. 1 hour break for 37 hours. I myself was standing on the road, seeing that the immersion is in place. Where is my 8-hour duty and 12-hour duty? So showers, changing rooms, restrooms, and clean toilets. This is the basic minimum thing I should be able to give my personnel at the police station in order for him or her to feel that, yes, the institution is taking care for us. So these are some of the things that I'll finish it. So these are the what would you say, challenges we are facing at the police station level or at the field level. But out of all these duties that we mentioned, I did not mention that in urban policing, we are also doing the magisterial duties here. So a lot of magisterial work we have taken up in urban policing. Multifarious functions performed by one person. I have my SGPU who's doing this engagement with the community, coming back and investigating the case that she's doing the paperwork for that, going to the court, standing as a witness, giving her court disposition, coming back, standing on the road and doing a law and order duty. So we are doing all this. That is envisaged in the police reforms. So I will end this entire disposition with an appeal to academia that ma'am must have mentioned a lot of good practices, but there should be a compendium where these reforms, what we state, and what actually is happening at the police station level, that it should be there should be a compendium, there should be a study, there should be a disposition before the legislative assemblies that this is already happening. Now we should go beyond that. It is happening. What you have envisaged is already there. The service orientation has come in. The personnel are doing the job at the police station level. Now, what we need to do is we need to go beyond that. We need to have a structural arrangement. We need to have an institutional engagement. We need to have an institutional arrangement wherein a lot of human resource that you have at the police station level or at the field level is looked at as a human resource. And all the things that accrue to a human resource is accrued to them in order for them to feel some kind of allegiance to the duty that they are doing. Until and unless you do not have this institutional engagement, until and unless you do not have this sense of ownership between the state and the police. Okay, we are just going to be looked at as instruments of to be used. Where will I get the wherewithal to say, this is my lawful duty and I'm doing it according to the rule of law? I will say this only when I know that my state is standing behind me. And what do I need? I just need a structural arrangement, I need an institutional arrangement, and I need protection to do my duty. Today, if I have done X particular thing, I should not feel that I will be thrown into some kind of a thing. I'm a police officer, but I'm a mother at the end of the day. I have children. I cannot just, uproot my child from an urban place and hope to go and serve in some rural area where the school system might not be as good as in the urban places. So this kind of assurance for things should be something that we should now look at, rather than saying कि 1806 में जो law था वो अभी भी law है. It is not so, sir. We are changing. We have changed. We have adapted. We are responding. Now we need to go beyond that and put the police as the fulcrum of your engagement. See that you have a structural institutional arrangement in place, and then have a dialogue of how to establish the rule of law. I rest my case, sir. Thank you.
For that invaluable practical insight into organizational issues of the police department and institutional solutions also that you have suggested. We also want to say that we greatly appreciate and express our gratitude to the groundbreaking work that is being done in Zone 3 of the city and all your service. Thank you. With this, we come to the end of the deliberations of the panelists. We will be starting with a question and answer session. I would like to invite Professor Shubham Chandaria, Assistant Professor, to moderate these sessions, as we have had some questions on the Zoom platform and the YouTube platform as well. So we will be throwing questions back to the panel and awaiting your responses.
A very warm good afternoon to all the distinguished panelists present over here and all the participants. It was really intellectually enriching for all of us to hear, although these brief sessions, but these very pertinent sessions on the topic of police, security, rule of law, and human rights. Now, due to the paucity of time, we'll just be taking up a couple of questions from our online audience, and then I'll also open up the floor to our in-house participants to have any discourse or discussions with our panelists present over here. Now, firstly, we have received an online question which states that whether the rule of law activities in the peacekeeping are people-centered initiatives in a country like India, or are they more state-oriented? And further, how can these activities be tailored to our local realities and assist the communities to produce concrete peace dividends? I'll request all the panelist members to kindly address the same.
Would you like to respond? Could you please, Sting Police Officer?
Yes, ma'am, the question is whether the rule of law activities in our country, are they more tailored towards a people-centric approach, or are they towards a more state-centered approach? Further on, how can policing or rule of law peacekeeping activity can be tailored to ground level realities or local realities?
Rule of law is a very non-personal generic term, and having said that, rule of law is for the people and for their safety. So it is not state-oriented. It is rule of law is for the people, their safety and procedures. Having said that, rule of law is all about a set of legal things that one is supposed to do in order to ensure human rights, in order to ensure human freedom, in order to ensure fundamental rights. So, and all these are people-centric. So to say that it is state-oriented, it is state-driven, it is not true. Rule of law is for the people. And the second aspect of it, what was the second question?
Ma'am, the second question was, how can policing be adjusted to our ground realities or local realities?
So, policing, the entire base of our work is the rule of law. Okay, we work within the confines of rule of law. so to say, person becomes the center of our service. And when we function within the rule of law, there are certain procedures, as Madam had said, there are certain procedures of arrest, there are certain procedures of freedom that we have to take into account. Various Supreme Court judgments are there that give us directions on how to conduct arrest, or how to bring a person to the court. So all these are directed towards ensuring that fundamental right of a person, freedom of a person, human right of a person is not infringed upon. And we at the field level do our best. There are aberrations, no doubt about it. But we at the police, at the field level, ensure that we, since we are custodians of the rule of law, we follow it to the T.
Thank you.
Whether Professor Akshat Mehta wants to respond to this question.
Yeah, ma'am, thank you. I fully, echo the sentiments and the dimensions expressed by Madam Gaikwad out here. Primarily because when we say that is it state-oriented or is it people-oriented, the entire structure is built like that the reflection of people's will is what is making the entire legislature and executive work. And ultimately, judiciary is looking into whether it is totally in tune with what the Constitution has laid down before us. So this entire debate sometimes gets distorted. And I was very carefully listening to the discourse by Madam Gaikwad about perceptions and the gap sometimes of perceptions which remains between certain sections of the society vis-a-vis the functioning of policing as such. As the constitutional scheme of the things, it is the will of the people, which we express through the electoral politics. And that ensures that our will is something which becomes part and parcel of the governance mechanisms. So the only thing would be sometimes the involvement which as citizens people would expect to be there in the rule making has to be slightly more aware and informed kind of an involvement. The kind of representatives which we only choose and select and then send them, elect rather, is a reflection upon what we think at a moment of time and how do we send them. So every activity carried out by state is per se an activity which is a reflection of will of the people only. So that's one point which is very important. And as Madam already explained about the tailoring of certain peacekeeping activities to local realities, I believe the more openness as far as public and police relations are concerned, and she mentioned about Bharosa and a couple of other initiatives, including quote unquote the misfortune or fortune of visiting a police station, which some of the organizations have been looking forward to. To give one small example, we read through again the author David H. Bailey and others about forces of order, when he was making a comparison between American policing and Japanese policing and a couple of other places. So they were talking about on a weekend, what do families plan? Amongst other places where one could visit in terms of taking your children along, nearest police post, police station or a cubicle, Koban, is also one thing on the agenda of the families, that let's go and meet our uncle, auntie or elder brother or elder sister out there in a police station. Let's know about their uniforms, their commendation certificates being put out there on that particular police post as such. And that's how the culture of involving your youngsters into what is taking shape in and around them gets really ingrained within the youngsters, and then they live up to it for a pretty long period of time. So I think, local realities, police does take them into cognizance. The only aspect would be more and more understanding about one another's role and how difficult it is to step into the shoes of a police personnel with a lot of circumstantial constraints. And despite that, being there, standing there for ensuring that peacekeeping is ensured in our vicinity. So that's some thought processes I had about this question.
Thank
Thank you, sir. Yes.
Professor, from the UN context, would you like to respond?
I don't know. Then you can again.
Thank you. I wouldn't add much to what was context, because you asked for explicitly when it comes to rule of law activities in peacekeeping and mediation. I think, at least for me, there's no doubt that this was too much state-centered, but it came, of course, with the question of the mandate and the organization. And there is a discussion going on now and how this can become more centered. There are a few publications about this. And in my eyes, this is the way how we have to go forward. And I think the only way to bring it more to the people is to actually go very over there. I think from your example, we just learned how it is done. I think this theory that what you need is revised legislation, training to every police officer, and then automatically it will happen. I think it's something that didn't work. And I think you show with your example what does work. What works in my eyes is to train people and fellow officers by giving an example, by doing it. It's something where you show how it would look differently than it was before. And I like very much your last example about bringing children and get them into contact with the police. It's something that a lot of my friends in Germany are doing with their children. They go where the police is active because they don't want that people are afraid of police officers, but that they actually learn they can help them. So they go where police officers are. They just engage them so that children learn these are actually, it's part of realizing human rights and rule of law rather than the other way around. Thank you.
Thank you. Yeah, you can combine a few questions.
I just see one more question from the online audience. Sir, considering the fact that even the UN and other international bodies have also provided for a lot of regulations pertaining to use of force or even the use of force by law enforcement agencies, can you just point out to us some good examples which could be applied in the Indian context, especially considering the fact that we have a lot of incidences of, say, custodial deaths or even custodial torture, so to say. So can any of these principles be applied over here in India?
How to avoid torture or corporal ways of extracting truth. That be more use of technology in lie detectors and.
I don't know enough about the details to really say concretely in India, okay, this is what should apply. But what I can say is that at least in my practical experience, these guidelines have been very useful because you have a reference to actually look at what are the regulations and what is the practice, and then to actually see that there is another example. I would be very reluctant to try to use these guidelines and translate them one-on-one into every country context. This is not how they were developed. They were developed to actually assist states to translate legal obligations into more concrete action. But you have a reference point and a model. And by taking this model and looking at the situation on the ground and comparing the two, it's a good basis for coming up with maybe the best solution for that particular country. So in that way, I think they can be extremely useful.
Just have any of the other panel members like to contribute? Yes.
On this use of force and custodial deaths. First of all, I mean, I don't agree with the point that there are not too many custodial deaths in India. You have to compare. There are custodial deaths. There are custodial deaths in US also. There are custodial in UK also. So-called Western country. So therefore, how do you minimize it? That should be the maybe techniques of using latest technology, or maybe using different methods of interrogation. Maybe that is one point. But then we are actually well into the advanced stage of various kinds of interrogation. There are definitely students devise ways and means as to how to avoid it.
Thank you, sir.
So in response to these questions, I would like to make 3 points with the permission of all the panelists. One is that that policing itself is being taken on a professional level. The fact that we have Raksha Shakti University is a great example that right from constabulary level, there's a lot of process going in the Home Ministry on looking at policing as a training the police as professionals. Then their own self, what ma'am was saying, their own self-identity, their own self-esteem. So that is the consideration that the Home Minister was articulating many a times in order to establish more police universities like Raksha Shakti. So that's the first step, which I think will lead to not only top-down approach, but also bottom-up approach, where the police will bring their experience, like how ma'am put it, document it and urge towards reform from the ground level. Second, I wanted to suggest that with the current scenario of discretion being bound up with power than power with rule of law. I mean, those are the situations where miscalculations and miscarriage of justice or human rights compliance may happen. So this is where training process, probably in the armed forces and police as well, along with security and human rights conjunction, read with best performance. So today, efficiency, if it is relating to short-term, immediate ad hoc action, vis-a-vis considered human rights audit of the action, could be possible only if human rights is taken as one of the good choices that an officer can make. A good choice need not be independent of human rights, but the inevitable difference of human rights in rarest of the rare cases could be the approach rather than utter disregard for human rights, because it's a very dreaded word with the security forces, with the police forces. The minute they know you as a human rights activist, first thing is looking at you as a hostile element. So that kind of, I have seen police going far away from that in my last 10 years of interaction recently in Karnataka at least. And Maharashtra has been quite alert on this because of a lot of political literacy and human rights activism, very, very active in different parts. So in the light of that, I would say that in today's discussion, we got many themes for research emerging from the deliberations, careful deliberations by Madam and Sir, then from our Lieutenant General Sir, Rajendra Sir, and from Mr. Mehta, alongside the points that were raised by Professor Arvind Tiwari. So these should be the agenda for us in terms of creating a research project, maybe cross-country project and cross-university project along with Raksha Shakti and Tata Institute. That's where we could take it forward. So thank you very much for being the cause of this whole brainstorming and who have contributed richly by planning it so well, so meticulously, and esteemed officers like you, ma'am, who brought very rich experience to the table. Thank you very much.
So much distinguished panelists, ma'am. Now I'd like to call upon Dr. Aparajita Mohanty, ma'am, the Deputy Director Academics of Symbiosis Law School, Pune, to kindly deliver the vote of thanks.
Thank you, Professor Shruva. On behalf of management of Symbiosis, Director of Symbiosis Law School, Pune, and Dean of Faculty of Law, Symbiosis International University, Dr. Shashikala Gurpur, it is my honor and privilege to deliver the vote of thanks. I extend our sincere thanks to Lieutenant General Rajendra Nimborkar, sir, for sparing his valuable time and speaking on AFSPA from the perspective of J&K. I thank Dr. Strauss, Professor of Public Law, Department of Police and Security Management, for sharing his experiences on human rights-based policing best practices. I thank Dr. Arvind Tiwari, Professor and Dean, School of Law, Rights and Constitutional Governance, TISS, to have spared his valuable time and speaking on police accountability in India. We thank Dr. Arvind Patil, sir, ACP retired, for taking us through the hierarchy and functions of police administration and highlighting the nature of citizens' grievances. Thanks for highlighting the reforms suggested by Honorable Supreme Court. I thank Dr. Akshat Mehta, University Dean and Associate Professor, Rashtriya Raksha University, for taking up in a very apt manner the police reforms initiatives, taking us through the genesis of Police Act and various commissions, recommendations, and necessary reforms suggested through various judgments. Thanks for referring to the Model Police Act 2006 and highlighting the service orientation on the part of police administration. I thank Advocate Nilima Bhartak ma'am, former government leader, for highlighting the rights of the accused, rights of investigating officer, and custodial investigation. Thanks, ma'am, for bringing out all these various aspects in an effective manner. I thank DCP, Madam Purnima Gaikwad, for addressing us on field urban policing. Madam, thank you for sparing your valuable time and keeping the commitment to be part of this deliberation. Ma'am, your participation and inputs will strengthen the Police Academia Connect, which will be ultimately in the interest of the society. Thank you, ma'am, for highlighting the good governance practices which have been taken up by you for the emotional well-being of the police. I thank Dr. Gurgur, ma'am, for her wisdom and foresight, for planning and envisaging the round table at such a short notice. And ma'am, we are sure this is going to be the beginning point of the research project, cross-country as well as cross-institution research project, as you have rightly pointed out. I thank each faculty who have put up all their efforts and enthusiasm in planning and executing the event at such a short notice. A sincere note of thanks for your dedication and enthusiasm. I thank the members of program support team and PR media of Students Advisory Board who have helped us with the logistical supports in conducting the roundtable. I thank my colleague, Dr. Dhanaji Jadhav, Deputy Director Administration, Senior Office Superintendent Sonar Sir, IT team, for providing able support in all aspects of execution of this roundtable. I thank all faculty, students from our law school, members of academia from the faculty of law of different universities who have attended the session online. It's been a great learning experience, and I'm sure all of us have a lot of takeaways from today's events. I thank one and all, and with this we come to an end of today's roundtable, and I request the dignitaries to join us for lunch. And before that, may I also request the dignitaries to allow us to take a group photograph before we proceed for lunch. Thank you, one and all.
Yeah,